Good morning, everyone. Thank you all for joining us here today. The subcommittee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. Today's hearing will examine the administration's decision to deport children with critical illnesses, a decision that was recently reversed following public outrage and pressure from this subcommittee. I will now recognize myself for 5 minutes to give an opening statement, and then I will turn to the ranking member. We are here to get to the bottom of the administration's mysterious campaign to deport critically ill children and their families. It appears that this policy has thankfully been reversed after Congress and the American people rose up in an outcry at the cold inhumanity on display in this policy. I am going to treat this hearing as not only in honor of the memory of our late beloved Chairman Elijah Cummings, but as a hearing in direct pursuit of a policy objective that was close to his heart. The threatened deportation of sick children was such an outrage to Chairman Cummings that his very last official act before his death was to issue subpoenas to hold the administration to account. On Wednesday, in the waning hours of his life, through all of his pain and difficulty, Chairman Cummings recognized the indelible stain that this policy would leave on our nation, and he made holding the government accountable his final official act. And we now have a sacred obligation to follow through on his subpoenas to make sure that we defend some of the most vulnerable people on the planet, sick children who have come as strangers to our land to seek medical assistance. So to our witnesses today, I want to be clear, this subcommittee intends to follow through on Chairman Cummings' promise to unearth the truth behind this policy and his desire to ensure that the policy is truly reversed and that our government treats people in this category with the dignity that they deserve. Not only do we owe that to our late beloved chairman, but we owe it to Maria Isabel Bueso, to Jonathan Sanchez, to Serena Badia, and all of the immigrants whose health and whose lives were threatened by the policy implemented by USCIS. USCIS must explain first what the current policy is on deferred action. It cannot keep the process shrouded in secrecy while these kids wait to hear their fate. If we could go to this slide. On September 18th, Acting Secretary of Homeland Security Kevin McAleenan ordered the acting director, Mr. Cuccinelli, who's with us here today, to, quote, ensure that effective immediately USCIS resumes its consideration of non-military deferred action requests on a discretionary case-by-case basis. It is unclear whether USCIS has actually granted relief to anyone since reversing course. He further ordered USCIS to, quote, ensure that the procedure for considering and responding to deferred action requests is consistent throughout USCIS and that discretionary case-by-case deferred action is granted only based on compelling facts and circumstances. What exactly does this mean? What is the problem that USCIS is trying to fix? What changes are being considered? Will any outside stakeholders be consulted? We want to have maximum transparency to ensure that USCIS is not imposing unreasonable requirements on immigrants who deserve our attention and our mercy. In the meantime, USCIS should explain what will happen to people whose prior deferrals have expired while their renewals are still under review. We've heard from the family of a 12-year-old boy with an incurable condition that could cause him to bleed to death if he's not treated correctly. Both of his parents applied in March to renew their deferrals, but have been waiting for months without any decision at all. His father's deferral expired in August. His mother's deferral expires in January. Without a deferral, neither parent would be authorized to stay or work in the United States, threatening their ability to support and care for their sick son. So what does USCIS recommend families like his do while the agency is trying to decide how to reinstate deferred action? How many more people are stuck in this kind of limbo, and what will we do to protect them? We want basic answers to these questions, and we come here not in any kind of gotcha spirit. We just want to deal with a very serious problem that was brought to our committee. The ongoing confusion regarding deferred action reflects the same kind of chaos that apparently produced this policy in the first place and that prompted our last hearing, and for which the administration, I hope today, will provide us answers. What little we've been able to learn about how this policy came to be indicates that it was undertaken in haste without any effort to ascertain what its health and life-threatening effects would be on the people affected. At our hearing in September, we heard the compelling stories of people who were directly harmed by the policy. Isabel Bueso, a 24-year-old woman suffering from a rare disease, testified that deportation would be, quote, a death sentence for me. She told us, I want to live. I'm a human being with hopes and dreams in my life. Jonathan Sanchez, a 16-year-old suffering from cystic fibrosis, which is a disease that affects people in my family. Jonathan Sanchez told us that upon learning he was facing deportation, he broke down in tears, pleading, quote, I do not want to die. I don't want to die. If I go back to Honduras now, I will die. In his words, quote, it is incredibly unfair to kick out sick kids who are in the hospital or at home taking treatments and who are just trying to have better opportunities to live. It's obvious from the testimony that USCIS either did not realize what the real-world implications of its policy would be, or it knew and decided to go ahead anyway. Either reality, I think, would be damning. But the effects on Maria and Jonathan would have been entirely foreseeable if USCIS had sought public feedback before instituting the new policy. According to USCIS, it failed to consult a single external stakeholder before jeopardizing these families. Making matters worse, USCIS did not even issue any public announcement about the policy or provide any guidance to people in Maria and Jonathan's situation or any of the critically ill children and their families about what would come next and what they should be doing. Why not? What was the reason for the secrecy and the surprise? Is it USCIS's practice to implement massive policy shifts like this without providing public notice? Sadly, the threatened deportation of sick kids is just one example of this administration's mistreatment of immigrant children. It is not the only one. USCIS in particular has engaged in a pattern of developing policies that endanger children. Since, Mr. Cuccinelli, you took office, USCIS has eliminated automatic citizenship for some children of U.S. soldiers stationed overseas, introduced new barriers for immigrant kids fleeing domestic abuse in their home countries, and rolled out a public charge rule that has scared many parents into removing their children from essential health and nutrition services. Each of these acts is an affront to the central tenet of Chairman Cummings' philosophy that children are the living messengers that we send forward to a future that we ourselves will never see. The last hearing that Chairman Cummings attended was our September 11th hearing on this issue. Treating children with dignity was so important to him that he made a point to come down from Baltimore despite his advanced failing health. At that hearing, Elijah said, quote, I really do think that we are in a moral situation. People are striving to live. They are trying to breathe the air of our country. They're trying to be better. They're trying to be healthy. Chairman Cummings, who himself was striving to live at that moment, trying to be healthy, wanted these children to have the same access to medical treatment that he did. We will honor the chairman's memory and the humanity of all those seeking deferred action by remaining vigilant, conducting rigorous oversight, and working to guarantee that this administration treats immigrants with the dignity they deserve. I welcome today's witnesses, Mr. Cuccinelli and Mr. Albence. We're delighted that you came today, but we want to make sure that we see no further bureaucratic stonewalling and confusion on these matters. We want clarity. We're here for answers, and we will not stop until we get them. We thank you for coming, and I'm now delighted to recognize the distinguished ranking member of our committee, Mr. Roy.
Thank you, Mr. Chairman. Thank you, Mr. Cuccinelli, Mr. Albence. Thank you for coming up here and visiting with us today. I will reiterate what I said in a hearing last week, that obviously our continued prayers are with the family of Chairman Cummings and with his staff. We obviously had a great event here in the Capitol last week, and it was honored to participate in that. And we will continue to move forward in this committee, carrying forward the chairman's legacy and wanting to do what's right and to be better, right? I do want to say one thing as we head into this, that, and it will not surprise the chairman that I will raise this issue, that currently there are 2 depositions going on, and those depositions are, or at least 2 are scheduled today. One, I think, is going on now in another part of the Capitol, and it's impossible for me to be in 2 places at once. And so I'm sitting here as the ranking member of subcommittee, and I want to carry out my duties to do that. And I'm unable to go hear that, and then I'm unable to go easily see transcripts. I'm unable to easily catch up on what I'm missing because we're carrying out the duties of our day. I don't think that's the right way to carry out things. I know there's going to apparently be a vote tomorrow on something on this process, but I would just suggest that this is part of the problem in real time. So anybody watching this, this is the problem with this current broken process. Here I'm sitting, there are very few members here, at least on our side of the aisle. I would also note that I would say my prayers and well wishes to Mr. Heiss, whose father passed away yesterday, and so I know he's unable to join us today. But I don't think this is the way we should be conducting those kinds of inquiries. Today, we have a hearing titled "The Administration's Decision to Deport Critically Ill Children and Their Families." I would take issue with that title. I do not believe that is what the administration was seeking to do. I think that we're talking about a process change and that we ought to get to that. This is a topic that involves deferred action requests for people not lawfully present seeking to stay for sympathetic reasons. And this is not the first. We've had the hearing you mentioned on 9/11. But to be clear, deferred action is not a program. Deferred action is a decision. Right? It's a decision, and it's a judgment call reserved for those with prosecutorial powers. And we ought to treat it that way. And then we ought to have a discussion about policy changes, if there are any to be had, for anybody who's here and has overstayed a visa or sitting here and is in a situation that the chairman described. And we're just dealing with a policy change that would have taken USCIS out of a role it has no real underlying authority to carry out, if I understand it correctly. And it would then leave prosecutorial decision-making to those who actually have that power. At the time of the first hearing, USCIS had already announced that it would evaluate pending claims subject to an internal policy change. USCIS also sent a letter to the committee the day before the hearing noting that individuals who had sent deferred action requests to USCIS after August 7th were not under imminent threat of removal. It's my understanding that none of the deferred action individuals had been targeted for deportation. And in a letter sent to the committee on September 19th, the chairman notes, it's returning to the deferred action process that was in place on August 6th. So for better or worse, no one's being treated any differently than they were on August 6th. I think what we have here is a question about how to have the right policy. Each and every one of us have sympathy for anyone who is sick, living in uncertainty, but we need real solutions. No one here, no one in the administration wants anyone to not be able to get treatment or be treated unfairly or to live in uncertainty. But we've got to deal with the real world where we've got people here who lose status, and then we've got to figure out what to do with that. Perpetuating a stay here over your visa and beg for intermittent 2-year deferrals that are not really rooted in law and seek deferred action from those who don't actually prosecute and then actually leave them in additional limbo, that's not a good policy. Yet that's the existing policy. If Congress wants a different visa class or otherwise to solve the problem, it should act. And this is something I beat the drum on many issues. Congress wants to solve problems. Congress should act. Congress has the power to make policies. This isn't about gotcha politics. We should all seek a system rooted in sound policy. I would remind my Democratic colleagues that this reality was at the root of the SCOTUS decision regarding the so-called DAPA class and in the current debate on the Daca class. With respect to approving status for people who overstay their existing visas, we have deferred action, which by definition is prosecutorial discretion. That's what we're talking about here. We can't defer, we can't give a status to a group of people in the name of prosecutorial discretion. And for perspective, this hearing involves a situation that affects roughly 900 current people, and the policy is currently at the status quo ante. But let's think about what's actually happening right now. Border Patrol agents along the southern border encountered 1 million people trying to illegally enter the country this year. 1 million. Today we're talking about 900, and it's very important for each of those 900. But that number, the specific number is 977,509. Okay, there were, with plus inadmissibles, there were 1.148 million enforcement actions by CBP. So just putting in perspective the numbers, we're talking about 900 versus 851,000 that we're talking about here in apprehensions. We're not talking in this hearing about the 224 pounds of fentanyl seized crossing our southern border this last fiscal year. And one little sugar packet of fentanyl would kill everybody in this room. And we've got 224 pounds of it that come across our border. We're not having a hearing about the 1,700 inbound weapons CBP intercepted this year, up 300% from last year. We're not talking about the fact that CBP apprehended 1,200 gang members from 20 different gangs. There are roughly 576,000 immigrant fugitives in the United States today. 576,000. Over 500,000 people who have been given a final order of removal by a judge, and they're still wandering around the United States. According to ICE, they've seen a double-digit drop in criminal arrests this year due to the volume of personnel and resources they've had to deploy to the border. This is where we have interior enforcement, and we have real problems. Our border is porous and vulnerable to crimes by cartels and traffickers who are taking advantage of migrants. Traffickers abuse children as props for asylum. There were 473,000 family units this year. This is the highest on record. We could discuss the 5,400 recorded cases of fraud from alleged family units and the children who are being exploited as a golden ticket to come to the United States. Let's talk about those migrants getting abused today on the journey through Mexico. We had 50,000 apprehensions in September. 50,000. We're talking about the numbers being down. Why? Because they were down from over 100,000 in May. Yet that's the reality of what's happening on our border right now today. But we're not having hearings on that. We're having a hearing on something that has no discernible difference from where it was on August 6th. I understand the concern of the chairman about some of the questions about the policies, but we're talking about something that's been largely addressed with respect to the concerns that the majority has. And if we want to have a conversation about the policies, sit around a round table and figure out what we can do to have legislation that might address some of those concerns. But let's talk about the other things we could do. Fixing asylum, catch and release Flores, TVPRA. All these are things that we could fix on one piece of paper in one day if we had the will to do it. We could fund ICE and Border Patrol properly. We could fund ICE at the level that President Obama asked for, upwards of $1 billion that he asked for to deal with the unaccompanied alien children that were coming in 2014 and 2015. And yet we only got $200 billion for ICE in June after demanding to get a supplemental vote, and that $200 billion was constrained in not being able to use. This hearing today is about an issue that affects 900 people for whom we have great sympathy and we ought to address the issue. But on an average day this year, that is 3 times less than the total number of crossing during one Border Patrol shift. Think about that. One Border Patrol shift. Today's CBP apprehends roughly 1,400 migrants a day. On an average day in May, that number was 5,000. If the chairman wants to address the facts that these deferrals are not actual programs and are prosecutorial discretion, let's discuss that and figure out a system that will work and that we can work together to try to figure that out. But I'd love to do that in the context of our very, very broken immigration system and border security. Thank you, Mr. Chairman.
Mr. Roy, thank you for your very thoughtful remarks. And as always, I'm very eager to work with you and all of our colleagues on comprehensive immigration reform. But you correctly delineate what the object of today's hearing is, which is to focus on this question. And we're going to do it. And I think I'm very hopeful we'll get the answers that we need and we can move on to work on other stuff. There are several members of the committee who have come today, both out of their interest in the subject, but also in a tribute to Chairman Cummings. So without objection, I would wave them on. Mr. Ruda, Mr. Cooper, and Mr. Desaulniers are members of the broader committee who are joining those of us on the subcommittee, including Ms. Kelly and Mr. Gomez, who have arrived over here. And also, thank you, Mr. Roy, for telling us about Mr. Heiss's father. I was not aware of that. Our prayers and our thoughts go out to him. It seems like we're just going to too many funerals these days, but we're sending him the strength and encouragement. All right, with that, I want to formally welcome our witnesses today. Ken Cuccinelli, who's the Acting Director of the U.S. Citizenship and Immigration Services at Homeland Security. Welcome, Mr. Cuccinelli. And Matthew Albence, who's the Acting Director of the U.S. Immigration and Customs and Enforcement, ICE, at the U.S. Department of Homeland Security. If the witnesses would kindly rise and raise their right hands, I will begin by swearing you in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Then let the record show the witnesses have answered in the affirmative. Thank you. You may be seated. Please speak directly into the microphones without objection. Any written statements you brought with you or that you decide to provide will be made part of our record. And with that, Mr. Cuccinelli, you're now recognized to give an oral presentation of your testimony.
Good morning, Chairman Raskin, Ranking Member Roy, and distinguished members of the subcommittee. First, I want to express my condolences on the passing of Chairman Cummings, and I appreciate his dedication to representing the people of Maryland's 7th District for 23 years. My name is Ken Cuccinelli. I'm the Acting Director of United States Citizenship and Immigration Services. USCIS administers the nation's lawful immigration system. The agency's mission is to safeguard the integrity and promise of that system by efficiently and fairly adjudicating requests for immigration benefits while protecting Americans, securing the homeland, and honoring our values. I can tell you that I'm extremely proud of the work and professionalism I see every day by the employees at USCIS in service to America. In fiscal year 2019, just ended, USCIS achieved many of President Trump's goals to make our immigration system work better for America. As an agency, we've tirelessly worked hand in hand with our fellow DHS components to answer President Trump's call to address the ongoing crisis at our southern border. We've taken significant steps to mitigate the loopholes in our asylum system, particularly in the absence of congressional action, combating fraudulent and frivolous claims, and strengthening the protections we have in place to preserve humanitarian assistance for those truly eligible for it. The workload USCIS faces each year is staggering. In fiscal year 2019, we adjudicated nearly 7.5 million requests for immigration benefits, a 14% increase over the previous fiscal year, and that is with only a 2% increase in fee income, demonstrating improved cost effectiveness even as we face many challenges. This workload represents the full spectrum of immigration benefits that our laws provide to those seeking to come to the United States, temporarily or permanently, and those who seek to become citizens of this nation. Last year, USCIS naturalized 833,000 new U.S. citizens, the most in more than a decade. Deferred action is the exercise of discretion to defer removal action on a case-by-case basis against an alien for a certain period of time. Deferred action is not an immigration benefit or specific form of relief, does not provide lawful immigration status, and does not excuse any past or future periods of unlawful presence. Importantly, deferred action can be terminated at any time at the agency's discretion. Historically, USCIS does not receive many non-military, non-Daca deferred action requests. For the past few years, USCIS has received approximately 1,000 such requests annually. Some of these requests are for family support or medical issues. This has frequently been incorrectly reported or mischaracterized by the media and some in Congress as a medical deferred action program. To be clear, DHS does not and has never administered a medical deferred action program. Only Congress can provide permanent immigration relief to an entire class of aliens. Deferred action is a practice in which the Secretary exercises enforcement discretion to notify an alien of the agency's decision to forbear from seeking the alien's removal for a designated period of time. However, USCIS does not enforce orders of removal. Thus, to better align USCIS with its mission of administering our nation's lawful immigration system, on August 7th, USCIS determined that its field offices would no longer accept non-military requests for deferred action. This redirection of agency resources did not affect Daca, which remains in effect according to the nationwide injunction while cases go through the court system. It also did not affect other deferred action requests processed at USCIS service centers under statute or other policies, regulations, or court orders. On September 2nd, USCIS announced that the agency would reopen previously pending non-military deferred action requests. Further, on September 18th, Acting Secretary McLean directed USCIS to resume consideration of non-military deferred action requests on a discretionary case-by-case basis, except as otherwise required by an applicable statute, regulation, or court order. The Acting Secretary further directed USCIS to ensure that the procedure for considering and responding to deferred action requests is consistent throughout USCIS, and that discretionary case-by-case deferred action is granted only based on compelling facts and circumstances. All cases that were denied around August 7, 2019 have now been reopened and are being considered pursuant to the Acting Secretary's September 18th directive. And that concludes my statement. Thank you.
Good morning, Chairman Raskin, Ranking Member Roy, and distinguished members of the subcommittee. I also want to express my condolences on the passing of Chairman Cummings. As you know, on September 11th, 2019, ICE testified on this matter before this committee. At the time of that hearing, the ICE witness, the Acting Executive Associate Director for Enforcement and Removal Operations, Tim Robbins, stated that he was not aware of anyone at ICE being involved in the decision to end the program. He further explained that ICE lacks any program or mechanics to consider affirmative deferred action requests, but described a variety of ways that ICE does utilize its discretion, as appropriate, on a case-by-case basis throughout the immigration enforcement process. Contrary to claims made by this committee and the media about the willingness to answer questions during that hearing, the only questions our witness declined to answer regarded possible future actions being considered by the Acting Secretary of Homeland Security and questions related to internal USCIS issues of which he had no knowledge. And as the committee is aware, within a few days of the hearing, Acting Secretary McEleenan directed USCIS to resume consideration of non-military deferred action requests on a discretionary case-by-case basis. In addition to our previous testimony, ICE provided several responses to several follow-up questions from that hearing to the committee in a letter on September 24th, 2019. In another letter dated October 15th, 2019, DHS further clarified that ICE had no part in USCIS's previous decision. So even though ICE's discretionary abilities are not at issue here today, and as USCIS has resumed consideration of these requests, a process in which ICE is not involved, I am here today and prepared to answer questions you may have regarding ICE's role, or more specifically, lack thereof, in this matter. However, I want to clearly state that I believe this continued repetition of inaccurate information does a tremendous disservice to the dedicated, professional men and women of ICE, and just as importantly, it does a disservice to the American public who deserve transparency and facts regarding the operation of their government. In a day and age when individuals are committing violent acts on ICE offices and making threats against ICE officers, agents, employees, and their families, to continue to suggest that ICE had some role in this process is not only inaccurate, as confirmed by the information already provided to this committee, but also irresponsible. So I am here today to defend the men and women of ICE and to once again set the record straight. I look forward to your questions.
Thank you much for your testimony, both of you. And at this point, having permitted the several members to join the subcommittee on the dais who wanted to be with us today, Misters Ruda, Cooper, and Desaulniers, we will move to the 5-minute questioning portion, and I will recognize myself for 5 minutes first. Mr. Cuccinelli, threatening to deport sick kids was an appalling thing, and it was public revulsion at this prospect, which assembled us in our first hearing on it, and we were very glad that the administration reversed course and decided not to pursue that policy. But I want to ask you, what exactly is the policy in place for processing these requests now? I understand this compelling facts and circumstances standard that's been enunciated. Are you considering being in the country for purposes of receiving necessary medical treatment to be a compelling fact and circumstance?
Mr. Chairman, the acting secretary returned us essentially to the process we were in before August 7th, and I would note that there is no program. That's part of the challenge here. This is about withholding action, not undertaking a formal process. It's about withholding action, in fact. And you saw what the acting secretary wrote with respect to his phrase, granted on compelling facts and circumstances. That is the only, what I'd call substantive commentary that has been distributed to our workforce in terms of reopening these cases and how to process them. Otherwise, everything has continued as it was before.
Okay, so as I understand it, there were at least 424 families whose deferred action requests were pending on August 7th. They were denied. That's when they were told that if they didn't leave the country, they should report for possible deportation. But then they were automatically reopened after the reversal of the policy. Can you tell me how many of those requests, of those 424 families, have been approved at this point?
I can't relate to the specific 424, and those were ones given notice around August 7th. There were over 700 cases pending at that time. But we've completed, as of earlier this week, and since the reopening, 41 cases was the last number I heard at the beginning of the week. But I have no
41 cases where people were granted.
No, that's where I was going, Mr. Chairman. I have no idea whether those 41, how they relate to the 424 who were among those who got notices on August 7th.
Okay, but I got to say this is an occasion for some frustration because we requested a lot of documents on this, and I think we received one document, which was basically the statement that you had received about compelling facts and circumstances. So we don't know what's going on there. We are cheered that there was a formal reversal of the policy, but, and I understand that there's no formal program, but there was a policy of allowing people in this situation to stay in the country. Then it appeared there was a reversal of that policy and that we were going to summon these people essentially for deportation proceedings. Then there was congressional and public outrage, I think of a bipartisan character. That policy was reversed. But we want to make sure that what was going to take place on a sweeping and categorical level is not taking place at a less visible ad hoc level. We want to make sure that the prior policy really is reinstituted. And so is that your sense of what's going to happen with these 424 people? I mean, do we have to have a hearing on each of these cases? I guess that's what I'm asking you.
Well, of course, we don't testify about individual cases, and but I understand that you would like to see more written material, but we gave you, in response to one of the letters, the entire universe of what is written on this topic, and it didn't even cover one side of one page, because this is a pure process question in terms of how USCIS handles this internally. You know, for other things, standards are laid out, they're discussed, but we don't have a law here, we don't have a regulation. This isn't taking action, it's withholding action. And so beyond the Secretary's statement about grants only on compelling facts and circumstances, which I can't even compare to anything before August 7th because no equivalent existed before August 7th, that's the only item that has been added to the materials or information that an adjudicating officer might reference.
And the way I would treat that is that the policy before was that cases of people being in the country to receive medical treatment established a compelling reason to be here. And these are all compelling facts and circumstances. That's certainly the way that I would understand it. It's the way that I'm interpreting it. I think I speak for a lot of my colleagues in saying that we would not want this to be the occasion for the creation of a new bureaucratic narrowing of the possibilities for people to be in the country to continue the medical treatment that they were here to get. Well, my time is up, and I'm going to go ahead and recognize Ms. Maloney, but we'll come back around because we definitely have some more details that we want to get out of this situation. Thank you. And Ms. Maloney, you're recognized for 5 minutes. Or are you ready? Or, I'm ready. Oh, okay. Then I will recognize Mr. Roy. Okay. And we'll pass it down.
Thank you, Mr. Chairman, and thank you, gentlemen, for being here today. It is certainly a sensitive issue when we're talking about individuals that have medical problems, and it's always, we always want to make sure that we handle things properly. So I just want to make sure that for the record, everything's straight. We're talking about deferred action, which means we're deferring taking action against people that may or may not be in the country here or overstaying a visa or something like that. Is that correct?
Well, they are here illegally. That's
okay.
The request for the deferred action.
Okay. So it's a request for deferred action. And the rules currently under the law, you are just enforcing the law that's currently on the books?
That's correct.
Okay, you're not making law or anything else. You're just enforcing what's on the books.
That's correct.
So when people received letters that said, if you're not in the country legally, you need to show up, or you may, did the letter say action may be taken?
That's right.
So the word may was in there.
It is.
Okay, so it wasn't saying this was actually going to happen. It was going to say this may happen.
Correct, at the end of that time period. And they were form letters adopted from other usage in the agency, is pretty standard language. And at the end of that time period, adjudicating officers would then revisit the case about issuing an NTA or not.
So in other words, if I was a person that would have gotten one of those letters, I could have shown up and made my case, and I wouldn't have necessarily been forced to leave the country.
I mean, it could be the case that the NTA is not issued, but you know, of course, we never really reached that point in this process with the initial August 7th shutdown of this process, because it was reopened less than a month later.
Okay, but again, I don't think it was any person's intent to make people leave that had a medical problem. It was just making sure that the people that were here actually had a decision made to let them stay by the U.S. government.
Well, it would have taken USCIS out of the prosecutorial role of exercising prosecutorial discretion, which is what deferred action is. It would not have replaced it with anything else, and it is, and you know, had it rolled forward, then it would have been considered in the normal course following on those letters.
Okay, so in other words, what really needs to happen is we as Congress should set up some kind of law. I mean, I keep hearing program and everything else. It's not really a program. It's just the fact that we're not taking action on something that we should be.
That's absolutely correct. And I mean, there is an equivalent in the State Department context. There's B2 visa. People can come visit temporarily for medical purposes. They have a whole process set up for that. It is temporary, and that's established pursuant to law passed by Congress. What we're talking about today is not not based on law. It's not based on regulation. It is much like the executive creating law by deciding how to use deferred action, an inherent prosecutorial authority to achieve a goal. And if there's a goal on which Congress agrees should be achieved, and they pass a law to it, I promise you, we'll implement that law.
Okay. Okay, and I think that's an important distinction, that you're not trying to do anything other than enforce the laws of our nation. And if we as Congress think that law needs to be changed, and we make the changes, you will abide by the changes.
Absolutely.
Okay.
Absolutely.
And again, when we're doing a discretionary case-by-case scenario, I think that doesn't lead to any certainty for the people trying to enforce our law or for the people that need to come here and get treatment.
Well, it is not, even deferred action is not durable. It can be revoked at any time, and it isn't an immigration status. So it is, because it doesn't have a legal foundation, it is a very uncertain course for people to be on.
Yeah, I mean, deferred action, I mean, we can defer many things, and it doesn't necessarily make them legal. And I guess that's the point I want to say. We could decide we want to not enforce IRS law and not collect taxes from a certain amount of people and defer their taxes. That doesn't mean they still don't owe them. That doesn't mean they're following the law. And I guess the point I would say for this committee, rather than replowing the ground that we've already plowed, the decision has been changed, I would suggest that we give the administration and the individuals trying to enforce our law the tools they need, and Congress act on this rather than wasting time on other things. And I yield back. Thank you.
Thank you, Mr. Keller. I now recognize Ms. Kelly, the gentlelady from Illinois, for her 5 minutes of questioning.
Thank you, Mr. Chair. Mr. Albans, I want to understand ICE's role in this process. USCIS didn't notify the public about this disastrous decision they made in August. To add to the confusion, once the public found out through media reports, USCIS claimed that ICE would be handling medical deferred action requests going forward. At the time, ICE said it was never even informed of this handoff. According to press reports, ICE was quoted blindsided by the move from USCIS, and ICE was, quote, scrambling to respond. Mr. Albans, was that true? Were you blindsided?
Yes, as we've put in writing back to the committee, there were some discussions, over the years with regard to this process, but the ultimate decision and anything contemporaneous with that decision was made by CIS.
And when and how did you find out about the decision?
I want to say either my chief of staff or public affairs brought it to my attention.
And when was that?
I don't have the exact date. It's going to be when it hit the media. It would have been the day that we put out that statement. So I think that maybe the 25th or 27th of August, but I'm not exactly sure.
So that was the first time you learned that USCIS was telling the press that ICE would be taking over, deferring action requests?
As I believe so, yes.
Okay. We know from USCIS's written responses to the subcommittee on September 24th that the agency has been discussing ending deferred action since October 2017. In those same responses, when asked about collaboration with ICE, USCIS wrote, "We can confirm that discussions did take place prior to August 7th, 2019. So which is it? Was ICE blindsided by this decision, or had ICE been involved in planning this for months or even years?
Well, without getting too far into the deliberative process, as I mentioned, there were discussions that were held under prior leadership of both agencies with regard to this process, but that there had nothing been settled on that or agreements with regard to how that would go forward or be implemented, and those largely fell off the map until this reappeared when CIS moved forward on their own.
So you were aware of prior discussions. Was anyone at ICE aware of the exact discussions?
Again, without getting into the deliberative process, we discussed lots of different programs and issues. There were discussions as to whether or not this would be a good idea. These were not discussions or decisions that we were involved with. And then, as I mentioned, it kind of just fell off the map, and there was nothing recent with regard to those types of discussions.
Okay. Do you want ICE to assume responsibility for deferred action from USCIS?
So I think the Secretary has already spoken to that, but to that comment and to, as our witness testified a few weeks ago, ICE does not have a process or a mechanism to affirmatively adjudicate or provide any sort of deferred action. ICE exercises prosecutorial discretion throughout the enforcement continuum with regard to who to arrest, who to detain, and then ultimately, if the judge orders somebody removed, who actually gets removed. So we do have a process on the back end of that where somebody can file for a stay of removal if so ordered by an immigration judge, but that is where our prosecutorial discretion lies, and rightly so.
And have you discussed this with the acting secretary?
We may have had
or
one.
With USCIS?
I mean, I've spoken with the acting director, certainly, after the fact. I probably was in one meeting with the acting secretary, but largely, we have been removed from this process since it went forward because it was not something that ICE was involved in.
And what are your recommendations?
My recommendations are that it remains with the agency that is better equipped to adjudicate applications.
Okay. At any point in time, has ICE considered implementing a deferred action process similar to the one at USCIS, where an immigrant can proactively seek relief before entering deportation proceedings?
Not a proactive program. We will utilize deferred action in certain instances. For example, if there's a witness that we need in a criminal investigation, or somebody that's cooperating with a criminal investigation that we're working, or that another law enforcement agency has requested us to. But again, it's only in conjunction with our law enforcement mission.
And is ICE playing any role in the USCIS review and updating of this policy that
No.
the acting secretary ordered?
No, ma'am.
Do you agree with the decision to order critically ill children to leave the country within 3 days or face deportation?
Okay, I don't think that's what the letter said. What the letter required them to do was respond, and I should defer to Mr. Cuccinelli, but the letter required them to respond within 33 days to make a determination as to whether or not a notice to appear would be filed. A notice to appear is only the beginning part of that process. That begins the immigration court process. Ultimately, nobody can be removed from this country absent a removal order from an immigration judge. So that's where ICE steps in at the back end of that process. We're somebody to be every case evaluated on a case-by-case basis if somebody files a stay. But if somebody has a significant humanitarian concern, a medical issue to that sort, that's when ICE can exercise prosecutorial discretion and grant that stay.
I know I'm past my time, but here's a letter that says within 33 days of the date. So not what you're saying.
No, it says 33 days with a date, report to CIS for determination as to whether or not a notice to appear will be issued. That notice to appear is not a removal order. That notice to appear is what starts the immigration court process. Again, ultimately, only an immigration judge, except in certain circumstances that would not be relevant here, have the ability to issue a removal order.
Thank you, Mr. Robinson. The gentlelady's time has expired, but I know this is going to become an issue, so I do want to read that sentence just so we're all on the same page here. If this was sent to in this case, Maria Isabel Buesa Barrera, but it was the exact same letter that went out to hundreds of people, this is what caused the controversy and the crisis in the first place. If you are not authorized to remain in the United States, if you fail to depart the United States within 33 days of the date of this letter, USCIS may issue you a notice to appear and commence removal proceedings against you excuse me, with the immigration court. This may result in your being removed from the United States and found ineligible for a future visa or other U.S. immigration benefit. So that's what was sent to critically ill children. That's what caused the crisis. Again, we're delighted that there was a decision to reverse this new policy. And I'm with Mr. Cuccinelli. There was no program in place, but there was a policy of not pursuing these, I think for the reason that was implicit in something that our colleague Mr. Roy said, which is this is a very tiny number of people compared to the whole universe of people who are actual immigrants to the country, and most of them are here precisely to get medical treatment. So I'm going to, Mr. Roy has passed this round, and I'm going to recognize Ms. Maloney for her 5 minutes.
I want to thank the chairman for focusing on this important issue, and this is one of several hearings that he's initiated on the subject. And I'd like to ask Director Cuccinelli about the standards to be applied to deferred action programs. And I want to make sure that he understands that to many families, this is literally a life and death issue. Many people, some on the other side of the aisle, have indicated that they are not here legally, but many are here legally, and they are under deferred action, yet they're being threatened with deportation. And sitting in the front row behind you is Nicolas Espinosa, and he traveled here today to try to save his daughter's life. She is 7 years old, and her name is Julia, and there she is, Julia, fighting for her life. She is in a special treatment program at Seattle's Children's Hospital because she's had most of her lower intestine removed and needs a full team of doctors to keep her alive. Julia is a U.S. citizen, but her parents are not. Her mother is her nurse. Deferred action has allowed Julia's mom to stay in this country, but her deferral expired in September. Her father helps support her too. His deferral expired 3 days ago, and they have both applied for renewal this June, but still have not heard about their cases. It has not been decided, and Julia's doctors say that if she leaves this country and goes back to her home country, she will die. This gives her parents 3 options. I'd say she only has 3. Stay in the United States with their daughter, even though their deferrals have expired. Leave the country and leave their daughter behind without any family to take care of her. Or take their daughter home, at which point her doctors say she would surely die. So I want to politely and respectfully ask you, Mr. Cuccinelli, to look at Mr. Espinosa. He is right behind you. Mr. Espinosa, raise your hand so he can see you, and look him straight in the eye. And as a professional, ask him which of those options he should choose.
Madam Chairman, Dan Renaud was representing USCIS at the last hearing, and one of the things he said that I think humanizes the agency, and I don't mean my I mean the employees of the agency's position in many cases is that the hardest cases we have to deal with are the kinds of ones we're talking about today. They are cases where it is possible that the law calls for a very sympathetic person or family, in this case.
Reclaiming my time, because I don't have much time. And we had many people here in our hearings that were brought to this country by American scientists because they wanted to study their disease so that we could possibly save their lives and have medical research that could save the lives of many other people. And I feel it's a very human decision, but I think it's terribly wrong to deport someone who's come here illegally. In this case, she is here legally. But I would like to ask you, what would you decide if it was your child, if you're talking about humanizing the situation?
Any parent does whatever they can to care for the children.
Well, then, getting back to the specifics, can you say here today that Julia's parents will not be penalized for staying in the U.S. while they fight for the renewal of their request to stay here, which is pending? And in other ways, if you put a human face on it, this policy has a devastating effect on people. And if this administration claims that it has been reversed, they need to tell people clearly in writing to all the professionals in the government and to the people that are here exactly what this means in real time and what their real possibilities are. I find this language discretionary, case-by-case basis. What does this mean? Can you get back in writing to me? How does USCIS define it? My time is up, but I'd like to see in writing how you define this exactly for the purpose of review.
We do not. That's the answer, and I know you all don't like that answer. This is not an action, a program, or policy. It is the withholding of action. Madam Chairman, you just described what might make an excellent individual standard in a piece of legislation. People coming here and doing scientific studies and getting medical care sounds to me like it would make an excellent piece of legislation.
Well, simply
We don't have that.
put, one
We
last
don't have
question.
that.
Will we be applying exactly the same standard to deferred action going forward as the agency used in the past? Yes or no?
We did not pose any standards other than the case-by-case decision, which then goes up functionally to 4 regional directors who are career employees, and they talk to one another primarily to make sure that they are implementing this process consistently across the country. But there are no standards we've given them other than what you see here from the acting secretary of the language of compelling facts and circumstances, because we don't have a legal basis to do so. We would welcome that from you all.
Well, have you
but we
written
don't.
guidance?
The
Have you
gentleman.
provided training?
Thank you. The gentleman's time has expired. So thank you for your answer to that. There was one question embedded in the gentlelady's thoughtful line of questions, which was, what would your recommendation be to people in this situation? I heard you to say that parents will do, that all parents legitimately will do whatever they can for their kids, and I take that to mean that they should continue to stay and have their children treated.
Of course, all of you know, I can neither give them legal advice, nor will we sit here at a table in front of you and decide individual cases, accepting full well how sympathetic the case is, which is exactly why we use the kind of compelling facts and circumstances language that the Secretary did. But if you're looking for me to decide a case here, I cannot do that, and I believe you all know I cannot do that.
Okay, thank you. I am now pleased to recognize our distinguished colleague from Massachusetts, Ms. Presley, for her 5 minutes of questioning.
Thank you very much, Mr. Chairman. This hearing has been a long time coming, and there was some commentary from my colleague across the aisle saying that we have better things to work on and should not be wasting our time. I never want us to lose sight of the impact on real people's lives when we are talking about policy, and that is in fact why the American people sent us here. So we are not wasting our time. Gentlemen, it is disappointing that it took the threats of subpoenas to bring you before our committee today. In a moment, I'll turn more to your actions, but first, I want to center the families that have been impacted by this egregious policy shift. Families like my constituents, the Sanchez family, and Serena Ibanez and her mom, Conchita. I told them when I met them that I would fight for their children as if they were my own, and I intend to honor that. 16-year-old Jonathan bravely came before this committee and shared his story. He spoke of how cystic fibrosis has ravaged his body, and in fact, the tragic death of his younger sister in Honduras who suffered similarly. The reckless actions of your agency that have put his very ability to receive life-preserving medical care at risk are just unconscionable. For 83 days, Mr. Chairman, nearly 3 months now, we have been demanding answers out of this administration. Mr. Cuccinelli, you testified that you understand that we want more paperwork, but you simply don't have it. None of us here, we're in government, we don't want more paperwork. But what we do want are real answers and justice for these families and a peace of mind, and they deserve that, and their children deserve that. And so for nearly 3 months, we've been demanding answers out of this administration for its horrendous and calloused efforts to deport our critically ill immigrant neighbors and their families. And while I am relieved that the policy has been reversed, these families and the American people deserve answers. They deserve the certainty that they will be able to remain in this country. So I'd like to thank the brave families like these and countless others who, despite the traumatic and imminent fear of deportation and having to fight a life-threatening illness, stepped up and spoke out to shine a light on this injustice, as well as the attorneys and the advocacy organizations. I'd like to request unanimous consent to include statements for the record from the Lawyers Committee for Civil Rights in Boston, as well as the American Immigrant Lawyers Association.
Without objection, they'll be entered into the record.
Thank you. Now, gentlemen, your agencies have still failed to turn over a single document in response to our letter, and even in response to the subpoenas that our forever chairman, may he rest in power, Elijah Cummings, signed in his last official act before his transition. It's shameful but consistent. So I hope that you can answer the questions that I have. USCIS and ICE have continuously refused to identify who made the decision to end consideration of deferred action at USCIS. I can only assume it is because no one wants to put their name on such a disastrous, cruel, and un-American policy. And the government officials who made that decision ought to be held to account. Mr. Cuccinelli, I remind you that you are under oath before us today. Who made the decision that USCIS would stop accepting and processing deferred action requests on August 7th?
That was my decision as the acting director.
Okay, very good. And you stand behind that decision?
That decision's been reversed.
The reversal, yes, okay. But today, those families have received no notification confirming the reversal of that. Can you tell me why that is?
I think they have. We are a paper agency when it comes to matters like this. So when cases are closed, literally a physical file is wrapped up and mailed to a storage facility. And so when we reopen the cases, we literally have to...
Sorry, I'm running out of time. I apologize. I have to...
I'm just trying to answer the question.
No, I apologize, sir. I have to reclaim my time. So, Mr. Cuccinelli, would it be fair to say then that you are not aware of some of the most consequential decisions and policies coming out of your agency, since initially you said you did not know that it was coming?
I did not say that today.
Earlier today in your testimony. Okay. Yes or no, Mr. Cuccinelli, did anyone at the White House play a role in this decision?
This was an agency decision solely, and other than discussion within the Department of Homeland Security.
I'm sorry, did Stephen Miller play a role in this decision or not?
So I'm not going to get into specific commentary back and forth, but I made this decision. The only discussions had over the course of the...
Again, for the record.
Yes,
Mr.
this is for the
Cuccinelli,
record,
I
and as you
understand.
noted, I'm under oath, so I want to be completely truthful.
So then this
and I
is very
can't do
easy
that
to
if I can't
answer.
be complete.
So yes or no?
I'm not going to just answer the way you want me to answer. I'm going to give you an
No, I'm
honest and
asking you
accurate
to answer yes or no. Was the president involved in this decision?
We cannot, as you well know, talk about content of discussions with
I'm sorry, but
the
you just
White
said
House.
that you made the decision.
Yes.
Okay, so was the president involved, yes or no? That should be
I made
simple.
this decision
Was Stephen Miller?
alone.
The gentlelady's time has expired. Thank you very much, and we will go now to Ms. Miller.
Thank you, Chairman
Ms.
Rest.
Miller, you're recognized for 5 minutes.
Thank you. We have a crisis on our border. This year to date, we have had over 850,000 total apprehensions on our southern border. I commend and thank President Trump for stepping up and taking action, while my colleagues across the aisle have refused to appropriately and adequately address this crisis. During our last hearing on this topic, I posed a question to Mr. Homan regarding all of the rhetoric surrounding the crisis at our southern border, and now I want to propose it and pose it to you. Director Cuccinelli and Director Albans, has all of this rhetoric helped move the ball forward on solving our nation's larger immigration issues?
Madam Congresswoman, I cannot say that that's the case. Certainly there is extraordinary public interest in this subject, and so you expect a certain amount of rhetoric back and forth, but when it gets in the way of constructive discussions, and in fact it has to some degree in the very subject we're here talking about, deferred action, which we have focused on in medical cases, but I keep hearing reference to medical deferred action, which does not exist, by way of example of inaccuracy and that doesn't help the public discussion. And the hotter the rhetoric gets, the harder it is for people to step back and have a constructive discussion, even about our disagreements, and how to implement our agreements. The thrust of your question is hard to argue with, and I think all of us own some piece of that. But yet at USCIS, we'll just keep pressing forward to do the best job we can, whatever that environment is.
Thank you. Mr. Albans?
You are right in stating that we do have a border security crisis, both in terms of illegal aliens, but also in terms of opioids and other contraband that is being smuggled into and out of this country. ICE and DHS has frankly made clear for many weeks now that ICE was not involved in this process. Yet here I sit while we have a tremendous crisis at the border, tremendous opioid crisis. Last year we seized, Mr. Roy, you mentioned several hundred pounds. We seized 11,700 pounds of fentanyl. We have communities that are suffering greatly from the scourge of this drug. I am more than willing, and I probably have testified in front of Congress more than anybody from ICE within the past 2 to 3 years, more than willing to come and speak about anything that my agency does, and I'm proud to do so. But when I'm dragged into an issue that has nothing to do with what my agency does, it does take away resources, as I'm sure you understand, preparation for a hearing and paperwork and time. And I will also say that we did provide our documentation with regard to the subpoenas to DHS prior to the deadline that was established by this committee.
Well, as you may know, my district is ground zero with the opioid crisis, so it's very important to me. How has the strategy proposed by our president helped curb the flow of the illicit drugs?
So we have worked diligently, both domestically and internationally, with regard to trying to address the opioid crisis. As I mentioned, we seized more than almost 12,000 pounds last year. That's a significant increase over the prior year. We initiated more cases into narcotics smuggling organizations. We've expanded our border enforcement security teams to 69 this year, focusing a lot on the international mail facilities because we know that a lot of the precursors and the material necessary to create these opioids is coming from overseas, often from China. So we have dedicated the resources to where we think will have the most impact. Obviously, if Congress gives us more resources, we can certainly do more.
Just as an aside, I even noticed a year or so ago in my neighborhood, all of a sudden there were all of these personnel surrounding a house waiting on a mail delivery. So it happens everywhere. In your opening statement, you also mentioned threats and violent attacks on ICE officers, personnel, and their families. Can you shed some light on that?
It's unfortunate, and I think a lot of the danger that is being unnecessarily placed onto our personnel stems from misinformation or vilification or disgusting terms that are used to describe sworn federal law enforcement agencies and other federal civil servants. We have seen instances over the past several months with officers being assaulted. We had, thankfully, nobody was hurt, but we had individuals shoot into one of our buildings at night where our command center was, where we had officers working on getting criminal aliens out of the communities. And this heightened rhetoric, and I've testified in front of Congress before about this needs to, if Congress does not like, or those in Congress do not like the laws that we enforce, they have every ability to change them. But we are not, as sworn law enforcement officers, in a position to pick and choose what laws we should enforce. And I wouldn't think Congress would want the executive branch to override their decisions as to the laws they pass.
Thank you. The gentlelady's time has expired. Thank you for your questioning. By the way, Mr. Albans, I appreciate very much your answer to Ms. Miller. The ICE is here because of answers that were provided on September 24th by USCIS, which said that ICE had participated in discussions leading up to the original decision. We're still trying to get to the bottom of the decision, and that's why we're here. We want to make sure that we have clarity as to what the policy is, and we can figure out how this took place. With that, I go to Mr. Gomez for questioning for 5 minutes.
Mr. Chairman, thank you so much, and thank you for clarifying that. I was about to do that, but you beat me to it. Mr. Albans, I think Democrats would agree that we want you to focus on preventing illegal drugs from entering this country, or making sure that people that shouldn't be here are not here, people who are and illegal guns. That's why we're having this discussion, because all of a sudden, instead of focusing on that, there was a focus on kids who were terminally ill, right? These chronic illnesses that needed to be here. So that's why we do want you to focus on the other stuff. You mentioned that there was a discussion, and you couldn't get into who was in the discussion, involved in the discussion regarding deferred action. Could you tell me how far back the discussion at least started?
It would have been, I don't have the exact dates, obviously I was not party to it, but it would have been 3 ICE directors ago and 1 CIS director ago.
It's hard to keep track how many directors this administration's gone through, but how many months?
Pushing probably 1.5 to 2 years.
Okay, so about when this administration, 2018?
I would say probably 2018.
2017, okay.
18, not 17, 18.
18, okay. Thank you. I just wanted to get clarification on that. I want to go into just quickly into the questions. Mr. Cuccinelli, you apparently sent an email to the American Immigration Lawyers Association saying, quote, USCIS field offices are informing the public of the change in person and on an individual basis, end quote. This has seemed to be the approach that has led to panic and confusion, and I believe it was not acceptable. And Mr. Cuccinelli, according to a recent news report, you personally decided that it was not necessary to notify the public. Is that true?
Congressman, it is our typical practice when we change a process that isn't based in regulation or law to not do public notification. That's the rationale for having done it on a case-by-case basis.
So you did not notify the public. Okay. Well, why didn't you think it was necessary? Because of it was just a process? That's it? That's the way you did it, even though it was dealing with people's lives?
Well, sir, everything we do deals with people's lives, and you know, in various ways. But as I said, typically when we're changing a process and not changing legal standards or something else of that nature, guidance to adjudicators, for instance, then we do not have public announcements.
Your agency's September 24th response to the subcommittee, you said that you did not notify the public because this was merely a, quote, operational change, which is kind of what you're saying again.
Yes, sir.
Do you really think telling critically ill children and their families they have 33 days to leave the country or face deportation is merely an operational change?
Well, you're referencing the form letters that got sent out, and the reality is that
Don't tell me that
they
it wasn't
weren't
asking
facing-
for,
Do you want me
I
to
have it
answer
right
the
here.
question?
I have it right
Yeah,
here.
I know you do.
okay, what does it say?
It says that you may get an NTA. That's what it says.
It says very clearly, you are not authorized to remain in this country if you fail to depart the United States within 33 days of this letter, U.S. may issue. May, but
So-
it's pretty scary. I mean,
In case,
what happens if the IRS sent you a letter saying, hey, if you don't report to the IRS, we might begin to audit you? Will you be concerned about that?
I'd certainly pay attention to it. Yes, I would.
Exactly,
Perhaps,
exactly.
Perhaps it would help if you all knew that when anyone presents to USCIS, seeks a benefit and does not obtain some status that has them at least not here illegally.
I'm going to reclaim my time because I have a few more questions
We give
to ask
them
you.
a similar letter.
Let me ask you a few more questions. Did you approve this policy without even bothering to figure out how you would implement it?
No.
No, you did not. So what was your plan to notify people requesting deferred action in the general public if they knew that USCIS would stop considering deferred action request?
As you noted earlier, our plan was to notify them one at a time, individually and directly.
That was the plan. So you had no plan, but you did? Didn't you
That
just-
was the plan.
Just to notify them?
Yes.
But then you also stated that the function would be transferred over to,
No.
ICE?
No, sir. No, that is a dramatic mischaracterization, and I think it's how ICE got dragged into this in the first place. There was never any suggestion anywhere by anyone that we were going to transfer some affirmative application process for deferred action over to ICE. That has never, ever been the case.
but Mr. Albans just testified that he was first notified by a public affairs officer that learned about it through the press. That was not correct?
But it is not transferring this to ICE. ICE has their own discretionary authority, which Mr. Albans described. We were, to put it in simple terms, ceasing the use of this discretionary authority, which dates all the way back to INS.
When you decided to reverse the policy, why didn't you choose to issue a new, like a news alert, a public release, something that said that was being reversed?
Gentleman's time has expired. You may answer the question.
Yeah, if you're referring to the Secretary's reversal, we did do that.
Regarding September,
He's referring to the initial policy.
Well, I thought I heard reversal.
your full policy reversal on September 18th?
Yes, sir, that was publicly announced.
Okay, I don't have that.
Okay, the gentleman's time has expired. We'll come to...
Thank you so much.
Thank you. We'll come to Mr. Roy for 5 minutes of questioning.
Thank you, Mr. Chairman. Mr. Albans, it falls under ICE for removal proceedings, correct?
That's correct.
Mr. Cuccinelli, let me ask you a question. Has Congress, this august body, created a status for individuals who overstay visa or come here illegally?
No.
Is there a law directing USCIS to give status to any of the individuals we're talking about here today that Congress has made clear and put into law?
No.
My colleagues mentioned a compelling reason to be here as a standard of some sort. Is that a visa category?
No, and it's very difficult to talk about at a policy level about how it would affect any particular case, because by definition, it's case by case.
Is it a status?
No.
Is it as a human being, as a Christian, or as someone of faith, or looking at someone through the eyes of a human being, something that's concerning, a compelling reason to be here, somebody who's sick? Sure.
Absolutely.
Is anything in the letter that was sent on August, whatever it was, 7th, factually untrue?
No.
Was it legally correct?
Yes.
Might people quibble over tone, but it was factually correct? Sure. Now, you said you made a decision to change procedures.
Yes.
My perception of the procedures, so I can try to figure out the policy, which is what Congress should theoretically be in the job of doing. If one overstays your visa or comes here illegally, and you face a health issue and you're getting care, in the process, you were here, you had status, you were here illegally, or you were on you had status, you were getting care, now you're overstaying your visa. And the process really is essentially to go to USCIS and to beg for some sort of intermittent 2-year deferral from an entity, USCIS, without it being really rooted in any law that Congress has put forward, and to seek deferred action from, in essence, ICE by way of a USCIS letter when USCIS doesn't actually prosecute, and therefore you're effectively leaving these individuals in limbo. Do I have roughly the characterization correct?
Yes, and it might help people to understand. The reason I said this goes back to INS days. Back in INS, the same person as a regional director had the prosecutorial authority that ICE now manages and the USCIS authority at the same time. That was all in one person. When INS was broken up, in the initial distribution of authorities, this was just given to the 3 agencies, and I don't think with much consideration of what's the difference between CBP, ICE, and USCIS as it relates to something like we're talking about.
So in trying to clarify the procedures, were you, can you clarify why you were trying to clarify those procedures?
So several years ago, the president indicated publicly that he wanted us to stop utilizing, essentially expanding the law to provide benefits that aren't provided by Congress or by regulation. And that's been an ongoing process at USCIS. There are lots of little things that have already taken place, all publicly known. This is along those lines, which is why I understand Francis Cisna, then the director, all the way back at the end of 2017, in conversations with field leadership, determined that this was one of those types of, just descriptively, authorities, and to start working to back out of utilizing that authority because it wasn't appropriate for USCIS's mission.
And isn't this at the core of the question here, right? I mean, on so many levels, I get frustrated that Congress doesn't act. I get frustrated that Congress doesn't act with respect to the authorization of the use of military force. 18 years after we passed the first one in 2001, we have men and women enlisting into the military who weren't alive when we passed that authorization of force. In the spring, I introduced legislation called the Article 1 Act that would have national emergency declarations expire after a year. I happen to believe that regardless of who's in the White House, Congress should reclaim its authority. Congress should act. Congress should do what we're supposed to do, which is pass laws and then hold you all accountable for carrying out those laws. And it strikes me that part of the problem we have here in this case, but also with things like Daca and DAPA, right? So let's, in terms of whoever's in the White House, doesn't matter to me. Like, let's have clarity in the law, but let's not expect bureaucrats, respectfully, those in the agencies to be making policies on the margins of the law that Congress passes. So if we have, in the case of DAPA and DACA, which when I was in the first Assistant Attorney General of Texas, we litigated and went to the United States Supreme Court, the question was whether or not conferring status and benefits to a class of individuals is something you could plausibly say is actually prosecutorial discretion. And it's ridiculous for Congress to be building a policy on the back of asking bureaucrats to make those decisions when we hold the pen and we could decide what laws we want to put in place. Would you agree with that?
Yes, you're not building a policy. You're telling us to implement a policy. You're not giving us standards. You're asking us for standards that don't exist in law. And as I said earlier, pass a law, I promise you, we will implement it.
All right, and the gentleman's time has expired. I want to thank Mr. Roy for his thoughtful comments. I do want to say I concur with a lot of your sentiments about Article 1 and the exercise of congressional power. On the DACA question, the House of Representatives has passed the DREAM Act, and it is over in the Senate, so we're waiting for Senate action. So it takes two to tango here in the United States Congress. It's not just the House side, it's the Senate as well in order to have effective Article 1 action. All right, with that, I will recognize Ms. Wasserman-Schultz for her 5 minutes of questioning.
Thank you, Mr. Chairman. Mr. Cuccinelli, under your leadership, USCIS has actually bragged about systematically restricting legal immigration. And I think it's important for us all to be clear about what you have been aiming to accomplish. My constituents Americans across the country aren't fooled by this administration's specious attempts to distinguish between documented and undocumented immigration. You and Mr. Trump don't want anyone who looks or talks differently than Caucasian Americans to be allowed into this country.
That's false.
I'm sorry. Please don't interrupt me, and I'd like the time added
That's
back.
defamatory.
Excuse me. There's nothing defamatory about it, and
The
time is fine.
gentlelady controls the time, and the witness will get a chance to respond.
Thank you very much. You want to block all immigration and make life harder for immigrants, and you have demonstrated that you will pursue this heinous white supremacist ideology at all costs, even if it means making critically ill children your collateral damage in the process. And this goes to a comprehensive pattern of harm at USCIS under your leadership. In August, you announced the administration's new public charge rule, for example, which would deny legal status to immigrants who use social services. Mr. Cuccinelli, has USCIS done any analysis of how many children may stop receiving critical services due to fear of losing legal status under this rule? And I'd like you to answer that question, please.
After declaring that I am not a white supremacist, as you alluded,
You have had white supremacist
nor is the
policies.
president.
Okay.
Facts
matter.
Yes, they do. Yes,
Right.
they do. Truth
Which is why I'm
matters.
stating them here today.
Yes, no,
Please
you
answer the
certainly are
question.
not.
Please answer the question. How many
you're certainly
children-
cloaked in legislative
How many
privilege,
children
but that
may stop
means you can
receiving,
get away with
reclaiming
not
my
telling
time,
the truth.
how many children may stop receiving critical services due to fear of losing legal status under this rule? Yanking
You're
social
asking
services.
about public charge.
That's right.
I don't have that information in front of me.
Does anyone behind you have the information?
We came to talk about deferred action today.
I'm able to ask any question I'd like in your jurisdiction. and
That's
so-
fine, but I
Yeah,
came
you
and
have a policy.
prepared to
You're the
accommodate
head,
what this
Mr. Cuccinelli,
subcommittee
you are
wants.
reclaiming my time. You are the head of USCIS, and you're going to tell me that you established a policy on the public charge rule, and you don't know how many children off the top of your head it affected? Did you not think it through before you insisted that
That
would be the
rule's
new policy?
1,000 pages long, ma'am.
It's a pretty, so, when you're talking about affecting children, one would think that someone in your position, if you were going to establish such a heinous policy with such far and significant reach and potentially harm thousands of children, that you would know how many children it would affect. You don't know?
What you refer to as heinous policy is a 1996
Okay, I'm not asking you
law
for commentary on the
passed
policy.
on a wildly bipartisan basis.
Okay, but you have implemented a policy that yanks social services and denies the ability of
denies
children
nothing.
legal status to immigrate here if they are going to use social services. In fact, advocates have reported that immigrant families are terrified and that some have already dropped their children from essential programs like Medicaid and temporary assistance for needy families. When you announced this rule, you were asked whether it was consistent with the poem under the Statue of Liberty, which reads, quote, "Give me your tired, your poor, your huddled masses, yearning to breathe free." And in response, you said the poem was only referring to people coming from Europe, and people coming from Europe would not be a public charge. Do you think our immigrants...
I did not say that.
That is what you said.
That is not what I
Do you
said.
think, well, this certainly was the implication.
No,
is
it's
that-
what you would like to broadcast.
No,
but
no,
that is
I
absolutely
I heard you
inaccurate.
say it. I heard you defend it, and I want to know whether you think our immigration policies should treat immigrants from Europe differently from other immigrants from other parts of the world. And is the
No.
purpose of, you don't think so?
Correct.
Well, so then I'm not sure why you made that statement, because
Well, I
it certainly
didn't.
made it seem
You-
like
you
did. You
appended
said the
your
poem.
own piece
no,
to the end
you
of it.
said the poem was only referring to people coming from Europe. There's no doubt about that.
You added
And-
to the end of
and
that
the
statement.
implication was that people from Europe would not likely to be a public charge.
No, it was not.
Were you attempting to shut down the American dream for immigrants who may not be rich or white with this policy?
No.
Okay, we are the
obviously.
wealthiest country on earth. Surely we can live up to the spirit of Lady Liberty and open our arms to immigrant families who just want to make a better life for their children and not yank the rug out from under them as you have with this heinous public charge policy and the intimidation tactics that you've used to make sure that people understand that they're not welcome here if they're brown or if they need help.
That's
Thank you. I yield
false.
back the balance of my time.
That is utterly false.
It is not false.
The
and
lady
time
is
is not
yielded
yours.
back. The
Time is
balance
not
of-
yours.
With the
I
law
re-
back to
Thank you. I yield back the
1640.
balance
The lady
of
is
my
yielded
time,
back
and the
her time.
witness does
Turning
not
over
have
her
the
words.
floor.
I will now recognize Mr. Clay, the gentleman from Missouri, for his 5 minutes of questioning.
Thank you, Mr. Chair, and thank you for conducting this hearing. And the American Academy of Pediatrics, or AAP, represents over 67,000 pediatricians across the country. after USCIS decided to deport critically ill children, AAP wrote a letter to you, Acting Director Cuccinelli, and to Acting DHS Secretary Kevin Allen about the decision. AAP wrote, and I quote, "We implore you to reverse this decision so that countless children and their families can continue to apply for deferred action. For some children, this is a matter of life and death." Mr. Cuccinelli, have you read that letter? Turn on your mic for me, please. This subcommittee received 15 more letters from state chapters of the American Academy of Pediatrics in advance of our hearing in September. These letters include truly heartbreaking stories of children and families thrown into fear for their lives because of this situation. Doctors in Massachusetts reported that the family of a 10-year-old who had been blinded by eye cancer had been ordered to leave the country, along with the family of a 7-year-old suffering from severe epilepsy. Mr. Cuccinelli, did you know about either of these cases when USCIS decided to end deferred action?
Congressman, we don't read individual cases when making a procedural decision like that. So the answer to your question is no.
Well, did you think about maybe these kids needed some life-saving medical attention, man,
Well,
that they could only get here in this country?
Well, Congressman, we knew that as a practical matter, they had come to us seeking deferred action affirmatively. They weren't in removal proceedings. None of the cases we've talked about before USCIS were in removal proceedings. None were threatened with deportation. I have heard ICE people say that they were not on, none of these people would be on any targeted list. So when we withdrew from the exercise of deferred action in these circumstances, we knew that deferred action continued to be available to every single one of these sympathetic families.
Okay, listen to this one. Pediatricians in Indiana reported that parents of at least 2 infants in a neonatal intensive care unit received letters from USCIS telling them to leave the country within 33 days. Imagine that. You have just had a child that is so sick, she is in NICU. At the moment, your child's health should be the only thing you have to worry about. The U.S. government orders you to pack up and leave the country. Mr. Cuccinelli, did you know about these cases before USCIS decided to end deferred action?
Yeah, my answer is the same as the earlier examples, sir.
Which is?
We do not look at particular cases when making processes.
So you don't care?
No, you asked me, did I know?
No, I'm asking you.
You bet I care.
Do you care that
You bet I do.
somebody's in a
You bet I do. And it would be great if we could take
intensive
care of
unit
this.
about
We
to
had
die?
a law. If you cared enough to pass a law, we'd enforce
Let
it.
me ask you this. What would you recommend those parents do when they receive that letter?
Well, what
should they do?
What we expected most of them to do was very little, candidly. We send a lot of those letters out, and not in
What do you
circumstances like you're
expect them to
talking
do?
about.
You want them to leave the country, pack up their stuff, take their sick child and go?
Either that or make their case in the immigration process where it's appropriate to do so,
All
to
in
stay.
the middle, all in the middle of them being there trying, hoping and praying that they save their child's life?
Which is why deferred action continues to
How
exist
cruel.
elsewhere in DHS.
How cruel. Really? Really? I don't believe this. I yield back.
Thank you. The gentleman's time has expired. Thank you for your questioning, Mr. Clay. Mr. Grothman has joined us and would like to wave on to the committee, and without objection, we will wave him onto the committee or to the subcommittee. for purposes of questioning. Mr. Grothman, you are recognized now for 5 minutes.
First of all, I'd like to thank you for all the business, all the work you do. I've been down on the border myself. I know some of the challenges that, you guys are dealing with the illegal immigrant population, and I think it's very underappreciated. I think, given some of the stories I've heard, while I respect law enforcement in general, there are a few people who have to deal with as much as you folks do. Mr. Albence, in your opening statement, you mentioned violent attacks and threats on ICE offices and personnel and their families. Could you elaborate on that a little bit?
Certainly. We had an individual, and unfortunately have yet to be caught, that fired a weapon into one of our facilities where we had officers working. We've had protest groups lay our buildings under siege, threatening the individuals that work there, aggressive actions against them, many of whom, we have to remember, many of the people that work for us are not law enforcement officers. We have attorneys, we have mission support specialists, many of whom serve their country and their government 30, 40, 50 years and have done nothing but honorable work that entire time. And I think reckless language used to denigrate them as individuals and the service that they have done only serves to heighten and stir into action some people who might not be of right mind.
How is this committee's insistence on continuing hearings on this issue impacting you?
Well, as I mentioned previously, and as DHS has made clear, this was not anything that was involved. The decision on this process was CIS's. It's a CIS process that they made the decision on. Mr. Cuccinelli himself has already spoken that this is his decision. As you can understand, with an agency 20,000 strong, enforcing more than 400 criminal laws, things that serve as distractions, are very difficult for us to try to keep focus on the very important tasks we have, whether it's regard to getting criminal aliens out of our communities, whether it's regard to the opioid and fentanyl epidemic, or whether it's dealing with child predators and sexual exploitation. And even with all of this, the dedicated men and women of ICE show up every day and do the best they can for this country and uphold the oath that they took.
I'm sure the vast majority of people from my district respect what you're trying to do, and I feel it's very tragic when other people go after you. I'll give you another question. You've been in the news a lot lately talking about sanctuary cities, the harm they cause American families, both citizens and immigrants. I think the issue would be better explored by the Oversight Committee, by the House Oversight Committee overall. Would you agree?
I would welcome help from anyone in Congress that would like to give it to us.
Can you speak to the harms that sanctuary cities cause to us, cause to American citizens in general?
Certainly, and we had our EAD testify, I believe, in front of Senate Judiciary a few weeks ago. There are, every day, right now, as we speak, convicted criminal aliens that are walking out the front doors of jails because we have jurisdictions that will not cooperate with us. And unfortunately, many of these individuals will go out and commit further crimes. Those are preventable crimes. Those are preventable victims. And unfortunately, we have more jurisdictions that are choosing not to cooperate with us, choosing to put politics over public safety and putting their communities in harm's way, rather than remembering why we're here as law enforcement officers, and that's to keep every community safe and every person within that community.
Yeah, just horrible. I sometimes think of it, it's like my area. Sometimes these people who don't like putting criminals in jail, they don't live where the criminals live. It's all fine and good to send criminals out.
It's hard for me to understand sometimes where you have a jurisdiction which just arrested this exact same individual for a criminal violation, enforcing the laws that they were sworn to uphold, yet when we come to take enforcement action against that exact same individual, sometimes hours later, to enforce the laws that we are sworn to uphold, we were prevented from doing so.
Well, I think my guess is part of the answer. The people who prevent you from doing so live in the nicer parts of the communities where they don't have to worry about the crimes being committed. But at a Senate Judiciary hearing last week, one of our colleagues seemed confused about detainers in sanctuary cities and that ICE was looking for local law enforcement to detain innocent people. Could you set the record straight or maybe kind of educate some of these congressmen on what's going on?
So just like any other law enforcement agency, when we lodge a detainer, we do so based on probable cause. Most of the individuals against whom we lodge detainers are convicted criminals. On the civil immigration enforcement side, 70% of the people that we arrest come out of state jails and prisons. 90% of the people that we arrest, and this has been consistent for the better part of the last decade, are a convicted criminal, have a pending criminal charge, and then two smaller buckets within that, 90% are individuals who have been deported previously and illegally re-enter, which is a federal felony and one which we prosecute aggressively almost 7,000 times in 2018. And those are immigration fugitives, those who have had their day in immigration court, gone through the entire court process, and now have avoided complying with that order. And we have more than 576,000 immigration fugitives, a number that grows every day.
Thank you, Mr. Albans. The gentleman's time has expired. I now recognize the Vice Chair of the committee, Ms. Ocasio-Cortez, for her 5 minutes of questioning.
Thank you, Mr. Chair. Mr. Cuccinelli, I just wanted to confirm something that I had heard earlier with my colleague from Massachusetts. Did I hear correctly that it is your testimony today that you were the individual who made the decision to end deferred action?
Yeah, I'm the acting director when we implemented this, and I'm responsible for that. So at that time, it's my decision.
So it was your decision?
Yes, ma'am.
Okay, thank you. I actually greatly appreciate that because we've been trying to get to the bottom of that question for quite some time, and I'm sure it will help us in future examinations of this issue. Mr. Cuccinelli, in your agency's September 24th response to this committee, you stated that USCIS did not engage external stakeholders to solicit feedback on the anticipated consequences of your policy change. Why didn't you do that?
For something like this, where we are changing a process and we're not operating off of a legal or regulatory foundation, it is not a common practice. I'm not aware of any other instances where we would seek that kind of input.
So you did not consider the impact your decision would have on critically ill children before making this decision?
We understood that even with USCIS backing out of the role of affirmatively granting deferred action in a limited number of cases, that opportunity still existed within the entire DHS system.
I see. Mr. Cuccinelli, in August, you told Fox News that you, quote, see USCIS as a vetting agency, not a benefits agency. But Congress created USCIS separate from ICE and CBP to serve immigrants. In fact, it's USCIS's own policy manual that explains that Congress created the agency to, quote, focusing exclusively on the administration of benefit applications. So, Mr. Cuccinelli, USCIS is a benefits agency. Why do you consider it not to be one?
So perhaps the best way to put that is that I would characterize us as a vetting agency first, but also a benefits agency, because you all in Congress have laid out a whole lot of different benefits that we adjudicate for immigrants and potential immigrants to this country. So that is part of our business and mission, and my phrasing is to emphasize the role we also play as an element of Department of Homeland Security in ensuring the safety and security and integrity of both the country and that immigration system.
So, Mr. Cuccinelli, I think what's tough here is that, and while I respect that Congress hasn't done its job in many respects in defining immigration policy, it's been a failure for a very long time for Congress to be able to define a lot of policies correctly, but we still have created a mission for USCIS through which the agency can interpret the spirit of this law. And it says right here on USCIS's website, the agency's core values are defined as integrity, respect, innovation, and vigilance. And there's a reason that USCIS is separate from ICE and CBP. I don't understand how deporting critically ill kids is consistent with any of these values. Mr. Cuccinelli, do you believe that you treated children with cancer, cystic fibrosis, and other diseases with the dignity and courtesy of the mission of this agency when you decided in secret to end consideration of deferred action and ordered them to leave the country within 33 days or face deportation?
Yeah, there was nothing secret about what we did. Because it was a process change, we made individual notifications. But you yourself just referred to the ability to view the mission and the spirit, and it's one chain after another. There's no law or regulation in any of that. So we
Right.
do the best we can with fulfilling our role and limiting ourselves to our role, particularly when there is continuing avenue
Right.
of recourse
But
for these folks.
You have discretion in your role. And so here's the thing that I can't figure out, is that you have thousands, tens of thousands, hundreds of thousands of cases, if not millions. Millions of cases in this country, and you decided to prioritize the deportation of critically ill kids. And I'm trying to figure out why.
So we did not do that. We have gone through
Out of all the, but you
continuing
did, out of all,
process
reclaiming my
that-
time, reclaiming my time,
Well,
with
so
respect.
you asked a question, I
But
should
with
answer the
respect,
question.
with
And
respect,
implicit in
and I'll
the
give you a
question
moment,
was
I'll give
an
you a moment, but
accusation.
with respect. When you make this decision at a time, at a specific time, you're making this decision at the cost of other decisions. So why did you make this decision to deport critically ill kids before almost all the other decisions that you had to make as an agency?
So we didn't
The
decide.
gentlelady's time has expired. You can go ahead and answer the question.
We didn't decide to deport anyone. We made the decision at the end of a long road that predates me coming into my current position and discussions across DHS. But it was made on August 7th, and I was the director. So at that point, it is my decision. One of the things that Dan Renaud testified to from USCIS at the last hearing is that, to your point, there are trade-offs, as you note quite correctly, and handling 1,000 of these cases absorbs resources, which, by the way, we are not paid for, that would otherwise deal with approximately 2,000 naturalization cases. Now, we did more naturalizations last year than the whole decade. Nonetheless, there are still more pending, and I hear from many of you all legitimately about concerns about backlogs in some areas. We have improved in many areas, but we have limited resources, and this is an undertaking by USCIS that was and is going on, that has never been assigned by Congress, that has never been part of a regulation, and the authority to grant the same relief continues to exist even had USCIS not continued to participate in it in the way that we now do again.
Thank you, Mr. Cuccinelli. Gentlelady's time has expired. The gentlelady from the District of Columbia, Eleanor Holmes Norton, is recognized for her 5 minutes of questioning.
I want to thank Chairman Raskin for really this very necessary, I must say painfully necessary hearing. Of course, today's witnesses had not wanted the hearing before because they said they were in the midst of ongoing discussions with DHS to resolve it, and now, of course, they said it's been resolved, so what in the world should we come to Congress for, apparently not understanding the role of Congress in making sure that a matter does not reappear of this kind. Mr. Cuccinelli, you sent a letter to Chairman Raskin. The date was September 19th, informing him that DHS Secretary McClellan had, and here I'm quoting, directed USCIS to open consideration of non-military deferred requests, sick children of the kind under investigation today, on a discretionary case-by-case basis. Now, DHS has provided the committee with a September 18th memo from the acting secretary to you providing the same directive. Why was the decision made to reverse the policy on deferred action on a case-by-case basis when it came to these sick children?
That was not a change, Congresswoman Norton. It was always case-by-case. Deferred action, by definition, is a case-by-case consideration.
But there was a category.
No, ma'am, and there was no medical deferred action. You've sort of implied in your comment that this was just about people seeking medical concerns.
Sick children, sick
well,
children. We're
they are
interested
among,
in the sick
They are
children.
among those. We also get ADHD filings, and we have filings for people who are getting older, and that's their basis for the
So
claim.
there was no directive whatsoever to reverse the policy to case by case, and we did not understand the policy to be anything to be case by case before. So you're telling us it's always been case by case?
Yes.
That's your testimony.
Yes.
Obviously, you have to look at every case, but we're looking at the category of sick children. I want to. I'm asking you because of a decision that directly conflicts with the recommendation your agency reportedly prepared for the acting secretary just 10 days prior to reversal. And I'm referring to a memo that was apparently prepared by your policy and strategy chief for a September 9th meeting with Secretary McCleenan. You were selected to lead that meeting. Are you familiar with that memo?
I don't have it memorized, but I am familiar with what you're referring to.
The USCIS has not produced that memo for us, but the press reports indicated that the memo recommended that the Secretary revoke USCIS authority to grant requests for deferred action. Reportedly, it said, and here is the quote from the memo, runs counter to the President's agenda to enforce our existing laws and potentially contrary to his goal of making sure aliens are self-sufficient, end quote. Mr. Cuccinelli, did you direct your policy and strategy chief to send that memo that I just quoted from?
Well, we certainly did send a memo with recommendations to the Secretary before he made his ultimate decision. It included 6 or 7, as I recall, different alternatives.
Did you agree with that recommendation that the authority of USCIS to grant deferred action requests should be revoked? Particularly, I'm interested even as to these sick children.
It was a broader comment that with the breakup of INS, this authority was appropriate for the prosecutorial arms of the Department of Homeland Security.
So you did not push back even with respect to sick children?
And not appropriate for USCIS. So it wasn't just related to this category. And of course, you mentioned sick children, which I and I'm sure everyone else at USCIS are very sympathetic to, but that is a category. That is exactly the kind of thing we would look for in legislation, is a category. We do not have the power or authority to create a categorical grant of a benefit.
Mr. Chairman, I just want to indicate that, of course, there is administrative authority to create categories, but if they need legislation, maybe we need to tell them what they already know. I thank you very much, Mr. Chairman.
The gentlelady yields back, and perhaps you could pursue this with Ms. Norton, who was the chair of the EEOC, so she knows administrative law and policy very well. But it's an interesting conversation. Let's see. We come now to Mr. Desaulniers. He's recognized for 5 minutes of his questioning.
Thank you, Mr. Chairman. Mr. Cuccinelli, it's a little difficult for me to sit here and listen to you say it's the Congress's responsibility when this administration has, and the President has publicly said that the second article of the Constitution gives him the authority to do whatever he wants. And the amount of discretion that you have tried to, the administration, I should say, in this field have been challenged in court. The courts have so far upheld things like funding of the border wall, separation of children. So your attorney, I assume you believe in precedent. Deferred action started in the early 70s. I was told in the Nixon administration. There's been iterations all along allowing for discretion, administrative discretion. And then now suddenly you say the Congress needs to act. And I would like, as I said at the last hearing, the historical perspective, at least in the last 5 sessions, Senate Bill 744, the so-called Gang of 8 bill, 4 Republicans, 4 Democrats, passed out of the House with bipartisan support, led by Senator Schumer and Durbin and McCain and Rubio. Then it got over here, and we're told now through articles in the press and interviews by Mr. Bannon that he and others went to elements of the Republican caucus, and I'm not privy to this, but argued that that bill should never come up because it was a good wedge issue for politics. So it never came up. Recently, in the last session, Will Hurd, a very well-respected Republican member, and Pete Aguilar introduced a very similar bill. Again, the Speaker never brought it up. So any member is free to put a piece of legislation in and let the public see what it is, and I would encourage my colleagues on the other side to do that, and I'd be happy to work with them. But this context that it's everyone's fault defies what we've been told in the press about the dynamics in the other caucus. So having said that, I want to turn my attention specifically to one case, and you've talked about process, and you've been very dispassionate about it. Mr. Renaud, who was here last time, in the case of Isabel Bueso, who's become, the family's become dear friends. They came here legally, by the way. They were here legally under a tourist visa. They were invited to the United States under a federal program to be part of a medical trial that's kept her alive. She was 7 years old when she came here from Guatemala. She's now 24. Her doctor, a very well-respected doctor at the University of California, San Francisco Children's Facility in Oakland, says if she goes back to Guatemala, she will die because she can't get the weekly treatment she gets. So you said all of these people were here legally. In this case, at least, that's not the truth. Now, maybe we can argue some of the parameters of that, but I want to read the letter that she got, as I understand it, your direction from the field office director in San Francisco. Dear Ms. Bueso, thank you for your request for deferred action for U.S. Citizenship and Immigration Services field offices. No longer consider deferred action requests except those made according to the U.S. Department of Homeland Security policies for certain military members. The evidence of record shows that when you submitted your request, you were lawfully present in the United States. So even your department recognizes, contrary to your earlier comments, that she was here legally. Your period of authorized stay has expired. You are not authorized to remain in the United States. If you fail to depart the United States within 33 days of the date of this letter, USCIS may issue a notice to appear and commence removal proceedings against you in the immigration court. So Ms. Bueso, she was asked at the last meeting, how did she take this when she received this letter? She was at the hospital receiving treatment. Her mom gave her the letter, and she told us that she vomited, that she was so upset they had to take. So how can you, as dispassionately as you described this, Ms. Renaud said, I'm not finished, and there is a process here, and it's Congress's process. He said, Mr. Grothman, he wouldn't answer my questions, but questions Mr. Grothman, he said, oh, there would have been a file. We would have known about her. We would have pulled the file, and that should have gone up the chain of command. So did you ever hear about Isabel Bueso before you made this direction?
Before this was decided, no, sir.
Did you ever think of the consequences for people like her? Did you ever think that with all the other things you have to do, and I respect that, and I also respect the fact that Congress needs to come together, but you still have consequences, and as the record shows, multiple administrations, and she, in her case, was approved for deferred action by your administration. So all of a sudden, things changed. She's here, she's under a program, she's saving people's lives, Americans' lives and others, under a much respected American federal government program, and then she gets this letter. You're responsible for that. Would you care to respond?
When we withdrew on August 7th from granting affirmative requests for deferred action, we knew that that authority continued to exist, and anyone who would have received such a letter could have or would have been in a process where they could also get it from a more appropriate source other than us. And as Mr. Renaud, who you referenced, also said that day, the adjudicator who would have been dealing with a particular case, I believe is what Mr. Renaud was referring to, would have known about it. That doesn't mean that all, however many hundred cases, are all known at any given time by a regional director or the head of field operations or myself at any given time. And usually only a small portion of them are ever learned about.
So
The
should she be
gentleman's time has expired, and I'm going to recognize Mr. Cloud now for 5 minutes. He's arrived.
Thank you, Chairman. I apologize for my tardiness. I've been in the skiff. I would like to yield time to Mr. Roy.
I think my friend from Texas, I would have been in the skiff, but we've had competing circumstances here. And so I would just ask a couple of quick questions. Mr. Cuccinelli, I've heard a few of my colleagues on the other side of the aisle, particularly my colleague from New York, talk about benefits. Can you clarify for the record here whether or not there is or is not a benefit being conferred, or are we talking about, in essence, a discretion, a prosecutorial discretion choice as to how we handle these cases?
Well, it is deferred action is a prosecutorial discretion.
Right.
And we are not a prosecuting agency. The closest thing to that is simply issuing an NTA that starts a process that puts you into the prosecutorial process. We do not participate in that. That's where deferred action is historically existed and been appropriate. And frankly, it's inherent in that authority. It is not inherent in our authority at USCIS.
Right. Also, can you touched on this a little bit ago, the cost of adjudicating DACA applications like we're talking about here, these deferred actions, not just DACA, DAPA, but these deferred action cases, the cost of adjudicating those and what that means in terms of diverting resources from naturalization applications. You mentioned that before. Can you reiterate how important that is in the decision-making in a world of limited resources?
Yeah, and I didn't mean to suggest that the people doing this would automatically spend 100% of that time on naturalizations. I was just trying to give the subcommittee a point of reference. And the Congresswoman correctly alluded to the fact that there are trade-offs. If we're doing this, we're not doing something else. And we, like any other agency, struggle to keep up with our workload. But unlike most agencies of the federal government, we are 96+% fee-funded by part of the immigrant community we serve, and we have to operate on what amounts to a balanced budget function year to year. So we don't have the opportunity to come financially flex to absorb more work that hasn't been assigned by Congress or by law or regulation in some way.
One more clarifying question, then I want to yield back to my colleague from Texas. One of my colleagues referenced something about people who are here legally getting wrapped into this. And I just want to clarify for the record that is not the case, correct? I mean, when we go back to the letter in question in August, all that has been done, all that was attempting to be done was noticing folks who were here who did not have status. Then right. Congress has not produced a status for you to give, that this was a letter clarifying their status.
That's right, and just understand, you could have a situation where someone is coming back for a repeat deferred action request, and they do it within the 2-year time period that is traditionally, though there's no requirement that it be 2 years, granted. It can also be the duration of treatment if we can identify that. And at that point in time, they will at least be under the then existing deferred action grant.
Okay.
However you'd like to phrase that.
I will yield to my colleague from Texas.
Thank you. I only have about a minute left, but could you tell me what law authorizes USCIS to grant deferred action to any immigrant who's here illegally?
Well, there's no specific law that does that. This is a derived authority granted to the Secretary for use specifically in case-by-case circumstances that came when INS was broken up
So to be clear, the USCIS does not have a formally established medical deferred action program?
Absolutely not. Never has, and it's never existed in the Department of Homeland Security or its predecessor, INS, as far as I know.
Would you say that it's being treated as if it were a formally established
Certainly, a lot of the discussion sort of assumes a program that a lot of people use the medical deferred action title for, and I you know, there are other reasons people request deferred action other than medical. There are perfectly good human reasons, sympathetic reasons why we're talking about the medical, but other requests are made as well.
Okay, and how many requests for medical deferments do you receive each year?
If you count not just the requester, but family members who might be requesting to stay to be with another family member for medical reasons, probably in the 500 to 600 to 700 range.
Do you feel you have the resources to appropriately deal?
Well, I mean, we can do the work, but then we're not doing other work that is legally assigned. I mean, that's the trade-off.
Thank you, Chair.
Thank you very much, Mr. Cloud. Okay, but we're going to do one other round just to clean up some questions that are lingering in any member who would like to do a few more. I'm going to start with the gentlelady from Massachusetts, Ms. Presley. You're recognized for 5 minutes.
Thank you, Mr. Chairman. Again, our forever chairman, Elijah Cummings, reminded us that the charge of this committee is to be an efficient and effective pursuit of the truth. And so I'm encouraged that today we made some progress in that regard. And I want to thank you under oath for your honesty, Mr. Cuccinelli, and taking responsibility for that decision to reverse the policy. I want to ask you, it was previously mentioned on the record that your agency had done analysis to ascertain what would be the impact of such an abrupt policy change. Do you believe that your agency did enough analysis to assess that impact?
I'm sorry if I was unclear earlier. We didn't do any separate studies, for instance, like we might when preparing a regulation or something. It was internal discussion, not what I would characterize as a study.
Well, given that it was an abrupt policy that's to impact quite literally the lives of critically ill children, in hindsight, do you think that you should have done some analysis?
Well, I do think in the if I had it to do over again category, that I would not have applied it to people then pending, if for no other reason than to ease the information out and to not surprise them with a change in circumstances. That'd be the main thing I would do differently.
All right, Mr. Cuccinelli, it has been widely reported that the Office of Legal Counsel at the DOJ determined that you were not eligible to serve as Acting Secretary of Homeland Security under Vacancies Reform Act and the Homeland Security Act. It has also been reported that the Director of the Presidential Personnel Office at the White House has accepted this decision and briefed the President accordingly. Do you accept the decision of the DOJ and the Presidential Personnel Office that you are ineligible to serve as Acting Secretary?
I'm not privy to anything you just described, and so I cannot answer that question.
Well, it's public record, but you know, it's just, could you give me your visceral response?
As you may know, my last government post was Virginia State Government, and I am no expert. I know areas of the law very well, but I don't know them all. And one I don't know very well is federal employment law, including things like the Vacancies Act and so forth. And I have not studied it or looked at it.
Sure, but again, the Department of Justice and the Presidential Personnel Office have ruled that you are ineligible to serve as Acting Secretary. So if asked to serve contrary to the law, will you decline?
I would not do anything contrary to the law. If I understood something to be contrary to the law, I wouldn't do it.
All right, very good. If President Trump chooses either of you to replace Acting Secretary McClellan, will you commit to keeping deferred action protections in place at USCIS? And this is for both Mr. Cuccinelli and Mr. Albence.
I don't think it's appropriate to comment forward like that. I told you just here what I would characterize as I'll call it a mistake, because it was, to apply this retroactively in particular. I do think the underlying philosophy was correct, and I also understand that deferred action remains available for all the people, even had the USCIS policy gone forward. But I cannot tell you going forward what I would advise some other secretary to do, or what they would do, or even if I were the secretary.
Well, that's disappointing.
Because this is, I understand,
Mr.
ma'am.
Cuccinelli, you've accepted, respectfully, you have accepted responsibility for making this egregious policy reversal. You have also expressed regret, and just now you used the word mistake. And so I'm not sure why it is challenging for you to just offer, if you are the acting secretary, would you keep the deferred action protections in place at USCIS?
I don't expect to see any change regardless of who the secretary is unless the program itself changes
Reclaiming my time.
dramatically.
Mr. Albence, your response?
I mean, first, I don't think there's any reason to speculate that I might be the acting secretary, because I don't see that happening.
Would you keep the policy in place, sir? Yes or no?
I would certainly look at any decision going forward. I support the decision that Acting Secretary McAleenan made.
Reclaiming my time, in closing, I just want to remind my colleagues here today to not lose sight of why we are here, the families and their critically ill children whose lives are on the line. We've talked a lot about process, but this isn't about process, it's about people, and we should never forget that. Thank you, and I yield.
The gentlelady yields back. Thank you for your comments. Mr. Roy, any? The gentleman from Texas, Mr. Cloud, is recognized for 5 minutes.
Thank you, Chairman. Mr. Cuccinelli, you mentioned you started to get into the lack of resources to do what you are legally mandated to do. Could you speak to that?
Wow, I could use a lot more than 5 minutes on that, Congressman. You know, I'll start with what I think is the highest profile backlog we have, which I would say is accurately characterized as a backlog, and that is asylum cases. Over half of them are over 2 years old, and I'm referring to affirmative asylum cases. There's two ways to claim asylum. The Department of Justice, if they were here, would be talking about defensive asylum claims in immigration proceedings. We deal with affirmative asylum claims. We have about 340,000 cases pending. From as soon as I arrived, I began the work to plan and execute, and we're in the middle of executing a massive hiring campaign for asylum officers to start attacking that backlog more effectively. The main problem in attacking that backlog effectively is the crisis at the border. We broke records again for credible fear interviews last year, just to use one example. Reasonable fear interviews associated with the MPP program. The same people are doing that work. Those are and none of what I just described to you, Congressman, is paid for. None of it. So when we construct our fees, we have to build into those things we do charge for the costs of the things that we don't charge for, typically humanitarian work of a variety of forms.
Okay, you mentioned that this program's not formally established. Could you speak to what the process for formally establishing it would be?
Well, I mean, really, the only avenue is legislation. This authority, as I said, was around in INS days, and that was when prosecutorial authority was in a region, was residing in the same person who was responsible for all of our visa work, the benefits that I was talking with the Congresswoman about earlier. With the division of INS, those authorities were divided. But it appears, looking back, I wouldn't even call it a solution. The almost knee-jerk reaction was just to assign the same authority to all three agencies, even though we don't have prosecutorial responsibilities.
Right. Since USCIS is using your own discretion to provide deferred action, can you speak to some of the common illnesses that are normally granted deferred action for medical treatment?
I'm sorry, the common what?
Some of the common medical illnesses that you see that are granted?
So I have to say my information is anecdotal. Obviously, we've been talking about this, as you all have over the course of the last several months. So I used some of the I pulled a selection of cases, for instance, just to review at random to see what the cases look like. So to get an idea of what adjudicators' workload was associated with these and what they had to do and contend with. And it runs the gamut. I mean, it runs from the kind of cancer and cystic fibrosis we've heard about today, obviously among the most sympathetic types of situations you can imagine, to things that look, to me, even though I don't decide these cases, rather patently abusive. I use the ADHD example. Really? Just not in the same league. You know, people claiming getting older. And I also mentioned earlier, some of these, a good number of them, are not medical. There are other claims as to reasons they want to stay. And candidly, the cases we talk about here, even though we can't decide a case sitting at this table, are the ones that you would think are most likely to be found by a career employee, and that's who decides these, as, to use the Secretary's language, compelling facts and circumstances. But I can't sit here and prejudge them even favorably, even though I'm sympathetic to them.
And you mentioned that really when this comes down to it, it's our job to manage the resources and give you direction on them. Could you explain what's the best thing that we could do when it comes to what your job is to, you talk about the limited resources to do all these things.
Well,
Gentleman's time has expired. Please answer the question.
okay, I mean, don't make us guess. You know, Congresswoman Norton referenced her category of sick children, and she said category. If it's a category, you all should be assigning it to us. Of course, the Supreme Court's going to take up Daca on November 12th, and it follows the pattern of the Daca case that Ranking Member Roy mentioned. Can the executive branch use these inherent authorities that Congress hasn't given any direction on to create categorical grants of benefits? It is the position of this administration that we cannot do that. We will use the authorities we do have that are discretionary on a case-by-case basis. Nonetheless, at the beginning of this process on August 7th, it was understood that the authority to grant this relief would continue to exist at a different point in the process, and I know people don't necessarily want to, they'd rather go to USCIS than ICE, but the fact of the matter is that's the appropriate and historically appropriate, getting outside the federal government, place for prosecutorial discretion, and that's with a prosecutorial agency.
Thank you very much. I'm going to recognize Mr. Desaulniers for 5 minutes of further questioning.
Thank you, Mr. Chairman. You have mentioned waiting for legislative action, even though it's clear you have the discretion or the precedent is there for discretion. So what I would suggest to you, and I'd like a response, I have a private bill for Isabel. It's in judiciary right now. We're looking for support. We've had comments from legal experts. If there ever was an example of a need for a private bill, this is it. So I would ask in the interim for the specific case that as she goes through, and I'm being told by her attorney some of the questions are different than the last 4 times she went through this, that you would work with us. Because I assume you don't want to be back in the position where she's in the cover of national magazines, she's in the New York Times as an example, even though she may be a little bit different. So that's one. And then Ms. Presley and I are working with the committee. We're looking for Republicans to work with to tailor a bill for this group of people. That would help them. And in a normal functioning relationship between both parties in Congress and administration, we would be trying to work on something that, knowing that there'd be a give and take. So within that context, I hope, and I would like some kind of response from you, that you have the discretion to at least work with us to see if we can provide legislative remedy for this group of people and specifically for this person.
While I don't necessarily agree with your initial comment about precedent in our authority, we will absolutely work with you. And I want to make it very clear, we don't even have to agree with what you're doing to be willing to help you do it correctly and craft it correctly, we will do that and bring subject matter experts to help you do that. We would be glad to do that.
Well, I'm grateful for the help. Sounds a little patronizing, but I'll accept
Well,
that.
no, I mean,
we'll give you help
say it
in
that way
return.
simply because the nature of
that's
some of the
fine.
discussions, you know, people can have the opposite impression. It's not intended to be patronizing at all. It's intended to be, you know, to point out that's a function we view
Accepted,
as daily.
accepted. That was my Irish sense of humor. So in the process of how all this developed, you issued what came to the letter. You're going to eliminate deferred actions. There was this big public response. We had a, I thought, very bipartisan hearing here. And then there was discussion within the administration about what you should do about it. There's a memo that the press has got a hold of that was given to you by your policy director suggesting that you shouldn't backtrack, that you should keep as you originally were going to do. Is that true? And did you have an opinion at that time? And clearly at that time, that was after our hearing, you knew about Isabel and some of these other cases. So did you support the acting secretary's decision to change the policy on deferred action?
Yes, I thought it was particularly critical to get the question decided. And as I view our role when advising something like that, we gave him a wide variety of options, presented those to him. With respect to my earlier comments, both to Congresswoman Presley, where I noted that I did think it was a mistake to implement this on a retroactive basis. I freely concede that. But philosophically, it is appropriate or more appropriate for this authority to rest with the prosecutorial element of the Department of Homeland Security, which is not USCIS, and that these folks would still, while under different circumstances, be able to avail themselves of that.
Okay, so in this specific case, and this is for both of you, they're in limbo. They're in a legal bureaucratic limbo, the Buesos. Dad keeps working, and by the way, there was no public charge here. They paid for their insurance to be part of the program. They're taxpayers. They're beneficial to the economy and the community. Isabel went and got a degree with honors from Cal State East Bay. So how do we work to help them through this process until we get to the point where either she can get her deferred action and they're in this bureaucratic limbo?
Well, we have, as you know, reopened these cases, and I can't speak to timelines for particular cases, but I do know that we have commenced deciding them. I mean, we're getting through some of the work. We have seen an uptick in filings, I would note for you, since this public discussion began, and that's behind the Buesos in that they were already in the pipeline, if you will, so theirs would not be affected by that uptick. But I can't speak to exactly how long it would take for each of those cases to be decided. But I can check it separately when we leave here.
In the idea of working together, and I would be willing to help you in this regard, not being patronizing, hopefully, they're in this situation. It's a practical situation. If we could work to assure them they were going to have their due process as you currently outline it,
Right.
And if there's a gap in there, we're going to work through it until the decision-making, and then if we could work on legislation that would permanently correct, at least for this group of people or for her, that's what I'd like to hear.
Yeah, we'd be glad to do each one of those things.
All right, appreciate it. Yield back, Mr. Chairman.
Thank you very much. The gentleman from Kentucky, Mr. Massey, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for having a hearing on this important topic. I want to thank the witnesses for showing up and dispelling the misinformation that's been out in the press and the false narratives that we've heard for the last several weeks and months. Before I yield time to the ranking member here, I just want to lament that the full committee, this committee, is right now simultaneously conducting a bogus impeachment process, 3 stories underground beneath the Capitol Visitor Center in a closed room. You have to go through 3 doors to get there. And a lot of my colleagues who would like to be here today are down there, both on the Democratic side and the Republican side. So I just want to say I think it's a shame that that is simultaneously happening, not just that it's happening out of the view and sight and sound of the American public, but that it's happening at the same time as this important hearing. And with that, I'd like to yield the balance of my time to the ranking member, Chip Roy.
I think my friend from Kentucky, I've made that similar point before you were able to join, and I'll make it again. I agree with you. We shouldn't be having these things concurrently. This is too important of an issue, and this has been happening on a regular basis. Last week, I had to do the same thing on a different hearing where I was unable to participate in the depositions that are going on this important matter in a way that, as I will reiterate, it's very difficult to get transcripts. It's for even those of us on the committee. And you're trying to figure out how to go get information for a thing that's occurring right now that I can't physically be present for, and now I want to go try to figure out what I missed, and I can't do it in an easy fashion. And any of my colleagues who aren't on the committee can't do it. Now, again, some of this may get remedied tomorrow, not sure, but I happen to believe that the House rules indicate that the records of this body are the possession of each and every member. And we're supposed to be able to have access to those records and have an open process to be able to go see this information. And it's, I think, critically important for the American people to know that this is what's been going on and that we can't have the kind of full debate that we ought to have. I do want to just come back one thing, and at a little bit of risk of repetition, but it's, I think, really important. Because I appreciated some of the comments from my friend and colleague from California that maybe we could work with y'all and try to figure out how to solve any of the issues here from a policy perspective as a legislative body, act as a Congress to solve the issue. That what in carrying out the action that Mr. Cuccinelli carried out, and you can jump in here because I don't want to speak for you, but I'll characterize it in this way. One might say a letter could have been written a different way, or maybe we could have carried it out a different way, and this is what's been discussed, and Mr. Cuccinelli has said that, you know, maybe he had hoped it had done differently, but it has highlighted an issue that has been lingering where my colleague used the word limbo. Even with the letter from USCIS, you're in limbo. There is no status given. Right? And Mr. Cuccinelli, am I correct about that? In other words, USCIS gives a letter that basically says, here, you got a letter, hey, we USCIS, who have no authority to say whether or not ICE is going to exercise their prosecutorial discretion, we're giving you a letter that sort of says you might be okay for a couple of years. Is that roughly correct?
Roughly, yes.
Can you clean up my roughness?
I mean, that deferred action can be revoked at any time.
Right.
And in circumstances where there might be a reason for someone to be in removal proceedings, ICE and USCIS talk about those individual cases. They're rare, but they do happen, and we coordinate our efforts.
And again, going back to the beginning, was anyone being targeted, any one of these families in question, targeted for removal after said letter went out? So putting aside
No,
whatever...
absolutely not, no.
And so acknowledging the concerns of the families receiving the letters, I think everyone acknowledges the concern of how that was received. And we're all guilty of doing a lot of stuff in a lot of fast-paced environment, like getting out and executing, and then going, well, maybe we could have executed that better. But the question becomes, the letters go out as a process matter. None of these families were being targeted for removal, to the best of your knowledge?
Well, not to the best of my knowledge, no.
Mr. Albens, to the best of your knowledge?
No, I mean, we wouldn't even know they existed. Even that grant of deferred action is not something that would have come to our attention when CIS does that. So we don't even know these people exist.
Okay.
Would the gentleman yield just for a second?
Of course, I'd be happy.
I appreciate the tone. I think the caveat would be precedent. I mean, we've heard there's a long precedent in the evolution of deferred action, and in this case, in this family, they have been approved 4 times before, including by this administration. So I'm agreeing with you, but from their perspective, the precedent was what it was.
I see.
And-
May I address
Sir,
that? So now understanding what you may have meant by precedent a little better, Congressman, it is important to realize each review is a fresh review. And particularly in medical circumstances, those evolve, of course. And those would be reviewed anew each time. So perhaps I misunderstood your use of the word precedent previously.
Maybe we just disagree on perspective. From their perspective, previously their attorneys had said, you do this and this is the likely outcome. So you do need to go through the process. What changed was the unilateral decision to get rid of all deferred action. So that changed the precedent, is my point.
Okay, understood. Now I understand what you mean better.
And the last point I'll make, and I don't remember my time, but then I won't try to take any additional time after Mr. Massey.
Please take your time, Mr. Wright.
It would just be to say the precedent we're talking about is in my view, flawed precedent. In other words, it's a kind of patched together circumstance to deal with a population who is inherently in limbo, and it's not affirmatively set out. And so I get a little frustrated. Your tone, this has been great. Some, nameless they may be, come here to bluster about the evils of what's being transpired here and to try to impute to Mr. Cuccinelli or to any other members of DHS a desire to create harm for people, as opposed to have a system where the rule of law means something.
May I suggest sort of a rhetorical question, just
By all
a
means.
thought exercise? So an obvious way to think about this isn't case by case, it's asking the question for each person, where do you draw the line?
But thank
how do
you,
you do
Mr. Cuccinelli, for that, because that goes right to my closing thoughts here. And I want to start by thanking all the members of the committee for a very productive conversation. I want to thank both of you for participating, for educating us, and participating in what I think has been a constructive process. I want to thank you particularly, Mr. Cuccinelli, for expressing regret about the mistake that was made in what you said was the retroactive application of a shift in the presumption, I think. And I thank you for that. I do want to pose a question about that, though. And obviously, it caused great anguish among the families that were affected, and I assume that moved you. I know you to be a man with a heart, and so you were moved by what you saw. And you know, this may have looked like it was sort of easy pickings in terms of going over a whole series of administrative policies where, you know, one could just tighten the leash in some way, but suddenly it caused a major furor because of the anguish and pain that was affected for the families. But what does that mean about going forward, given the, you know, the compelling facts and circumstances standard that you're operating under? You said there's certain things look clear. We apparently all have consensus about cancer, cystic fibrosis, leukemia, very serious diseases that we've heard about from people coming forward. On the other end, I think you said this was almost humorous, aging, that people were, somebody was actually granted deferred action because they were aging.
I didn't say they were granted.
Oh, I see. Okay.
I just said we see those applications.
But would it be your intention, because I did look at the question of where your authority comes from. It's not totally made up authority. I think that in the June 2003 delegation to the Bureau of Citizenship and Immigration Services from the Secretary of Homeland Security, P was authority to grant voluntary departure and deferred action. So you are, you do have that delegation of authority. Presumably you could operate it either on kind of a more arbitrary case-by-case, everybody make up on their own rule standard, or what it seems like you're trending towards now, which is to develop certain categories that would strike everybody as commonsensical medical compelling need versus, you know, people want to be here to age in place in, you know, in the United States. Is that your thinking, that you would try to develop some directives for the people who actually make these decisions?
Okay, so a couple of points, Mr. Chairman. First of all, the authority you cite there in the Homeland Security Act is how you trace this back statutorily. It goes to the Secretary, but the purpose of deferred action is it is inherently a prosecutorial discretion. Thus my descriptions here today. So, and what you point to in the statute doesn't provide, other than case-by-case consideration, doesn't provide guidance or categories.
Okay, can I pause you there? And then maybe it's a question for Mr. Albans. Would you pursue deportation of people who'd been granted deferred action for a medical purpose? So do you know of any cases where that's happened? And do you have any intention in the future of doing that?
I'm not aware of any cases in which that would happen.
Okay, fair enough. So,
Excuse me, let me take, I'm not aware of any cases in which that has happened.
Gotcha.
I'm not saying that there's somebody that could have been granted medical deferred action, gets involved in some sort of...
I got you. Somebody could commit a crime while they were
Exactly,
here
so-
on deferred action for medical reasons. I got you for that. So, but is it your thought, Mr. Cuccinelli, that you would try to elaborate and specify what some of these circumstances are?
No, sir. To be clear, from the acting secretary, Secretary McLean, it is to continue it as a case-by-case. What we do internally is try, and I heard some comments a little different than this, is to maintain consistency. And the way we do that is that the 4 people who are regional directors, sort of at the top of decision chains in the field, talk together about these cases periodically as they feel the need. Those are not conversations I participate in about cases, to make sure that similarly situated people end up with similar outcomes, whether it's grants or denials. But that's just for consistency. It doesn't introduce any standards or measuring stick, if you will, to provide guidance as to how these may come out. We don't have any basis to do that.
All right, well, we might have a difference of opinion about that, whether your authority would include that. The only point I would make, and I appreciate what you just said about at least trying to develop consistency, but the point I would make is just when we say that there's a case-by-case method of decision-making, that just means that each of the facts is treated on their own presentation, but there still need to be rules and standards applied for the decision maker to decide how the decision is to be made.
And I think that's the nub.
Yes.
You know.
Well, let me just shift to another question. In my role as chair of the subcommittee, we've got to just get on top of the discovery here, which I think we can complete. We should be able to complete in relative short order. And again, we feel strongly about this in general because Congress, as the lawmaking branch of government, has the authority to receive any information we want in order to make the laws that we want to make. You properly chide us for not having comprehensively overhauled immigration law, but we can only do it if we get the information about everything that we need.
Can I provide you an update on that?
Okay, if you could, that would be great. Specifically with respect to a couple of things. One is the memo that was written on September 9th from Kathy Kovarik, which was announced to us, but we've never seen it. And so that's one thing that I know we would very much like to get. That was one of the things that Chairman Cummings signed the subpoena for. The other thing is that you received from Mr. McAleenan on September 18th his directives with respect to this matter, and he asked you for a memo 30 days after the date, and that passed a week or two ago, discussing your implementation of these directives. I don't know whether you brought that with you or you have.
I did not. That was just a simple update, but that's what.
If we could have that, that would be terrific, just because we don't have any update about anything that's happened at this point.
So to be clear, the document request, we are still in litigation. The plaintiffs have not dropped their cases, and so
Of course, but that has nothing to do with Congress. I mean, the Supreme Court's been clear about that.
Well, please let me finish.
Yeah.
What it does have to do is we have to review our materials to know our own position. So we're not, we're doing all of that gathering of documents and review now. So all of what we can provide, we certainly will.
Okay, this is one area of the law that I actually know very well, that anyone's requirement to comply with a congressional subpoena request for information is not stayed in any way by virtue of the existence of other legal proceedings or litigation. And we can get you all of the case authority on that. So, in other words, we can't wait for cases to be decided, appealed, removed, and so on.
I didn't mean to suggest that.
Yeah.
It just, it complicates our own review of materials as we gather them.
Okay. Well, let me just restate. We would at least like an answer from you today. If you can tell us, when will you be able to comply with the subpoena that Chairman Cummings signed on the day that he died? It's dated, several hours before he lost his life. So I feel very strongly about this. Do you know when you will be able to comply?
I know we're working to comply. I can't tell you sitting here now. I'd have to revisit with, and I didn't do this morning before I came, I'd have to revisit with the review team back in the office.
Okay. Can you tell me when you will be able to tell me when you can comply?
Well, we can at least give you at least an estimate by the end of today.
Okay, if you could tell us by the end of the day, we can get on a timetable. We want and we need that information. Mr. Albans, can you also comply with that timetable? Could you tell us by the end of the day when you would?
So I can't answer that question. We provided our material to the department on October 20th. So at this point, it's undergoing departmental review. It's outside of ICE's hands. Obviously, our material was much more limited than what Mr. Cuccinelli has. or are expected to be so. So they are reviewing it for deliberative and privileged information, and then when they're done that review, I'm sure they'll release it.
Okay, very good. All right, good. Well, all right. Well, actually, are there people with you today who can just tell us when that would be?
No, it's with the department. These are all ICE people, so it's with the Department of General Counsel. So that would be the entity that would have to answer that question. I can ask them and see when they think they'll have it clear, but
Okay, if you could get back to me.
yeah, I asked yesterday and got an unknown
Okay,
date yet, so.
if you get back as promptly as possible. Okay. Let's see, we have some letters for the record that I want to admit without objection. Let's see, we have letters from several disability organizations, the Interfaith Immigration Coalition, and the New York Legal Assistance Group, discussing the consequences of these policy changes for children who benefit from deferred action. I ask unanimous consent that these letters be entered into the hearing record. Without objection, they will be entered. Okay, and finally, Mr. Cuccinelli, I am seated in Mr. Cummings' chair, and so I am mindful of his extraordinary career and the fact that he always told us, we're here to help people, and I've got an opportunity with you here to just ask you about one other case that I've been unable to get an answer from the department about, and so I wonder if you would indulge me by just listening to this, okay? It regards the case of an Afghan national whose name is Mohammed Kamran, and he was a U.S. military interpreter for us in the Afghan war. He fled Afghanistan with his family under threat by the Taliban, and was unable to seek entry to the U.S. on a special immigrant visa. So he sought entry under humanitarian parole. He was denied as a matter of discretion. To the best of our knowledge, he served this country faithfully and admirably for nearly a decade as an interpreter for U.S. military operators who have written letters in his support and in his defense. Since fleeing to Pakistan, where he's still in hiding with his family, he's been beaten up multiple times by Pakistani police. Last week, he was arrested by the Pakistani military. Advocates for him in the U.S. report that he has been tortured, although he has finally been released, but he was subjected to torture while he was being held. So as the result of bipartisan advocacy, we have members on both sides of the aisle who have been working for him. His case for humanitarian parole was reopened, but on August 1, we were informed by you that he was again denied on a discretionary basis with the addition of the phrase lack of credibility, but there was no explanation of what that meant. And we've been denied the ability to have a classified briefing on the matter. I'm very concerned that Mr. Kamran will be killed or he will be disappeared in Pakistan by the forces that are against him, and the same fate may await him and his young daughters. And so I would like it if you would be able to get clarification for the basis of this denial. If there are real facts there that show that he or his young children are a security risk, then by all means, please let us know. We don't want security risks entering the country, but this is a guy who served our country with everything that he had, putting his life at risk. We have Republican and Democratic members who are asking you to take a look at it. Would you be willing to clarify his case for us? Would you be willing to provide a briefing for us on the status of the special immigrant visa program as it relates to wait times for processing and the drop-off, which has been radical, of acceptance of former interpreters who've served with us in combat zones? Would you be willing to work with us to see that there's justice in this case?
So with respect to the individual case, I would have to, I presume there's no privacy waiver from the individual, so I'd have to find out what I'm allowed to share. You know, we operate within privacy restrictions ourselves, and but I'm happy to go determine that and turn back around and recontact you.
Please do. I mean, his advocates, his advocates are asking us to do whatever we can to save his life from their perspective. He's someone who served with the Afghan government and with our country faithfully, honorably. The people who worked with them over there are asking us to take a look at his case. We know that there's been a dramatic drop in the numbers of interpreters who've been admitted to the country, and if that's just part of a general tightening of ability of people to get in, I don't think it's fair. If there's some reason that he shouldn't be admitted, then by all means, please show us that evidence. But if you'd be willing to meet with us or have someone from your staff come and meet with us, then I think we'd be doing a little bit of fairness in the spirit of Chairman Cummings.
So let me see how much detail I'm permitted to share, and whatever the answer to that is, I will let you know,
Okay.
report back, and then we can go from there in terms of share what we can.
I appreciate that. And if there's anything else, Mr. Roy?
I'll just say I thank the chairman for the last 10 or 15 minutes, 20 minutes in particular, not to say anything about the forum, but of the back and forth and give and take and the conversations with our colleague from California about how to move forward. So I appreciate that.
And I appreciate very much your participation, as always, of the ranking member. I understand from my staff that he has signed a privacy waiver release that Mr. Kamran has, so that's something that presumably we could meet about. You can double-check with your people.
That will be very significant.
I want to thank all of the witnesses today for your testimony. I know you've got important business to attend to, so we thank you very much. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witness to the chair, which will be forwarded to the witnesses for response. I ask you to please respond as quickly as possible if anybody has any follow-up questions. Mr. Desaulniers, I want to thank you for your endurance. The hearing is now adjourned.